I appreciate that.
They're the best.
They are the best.
They
And
make
I
me-
think,
they
I think
make me
Brian
look good.
Caffarelli said there's might be a meeting tomorrow at 10. I'm going to try to attend.
Well, you've worked with me for a long time. You know it's not me, it's the staff. So, as Deb made me look good back in the day, many times.
She makes us all look good. Are you ready?
Yeah.
We are ready to go. Thank you.
Okay. So I'm going to call to order this public hearing. It's of the Judiciary Committee for Monday, March 8th. I have no comments. Representative Kissel, Senator Kissel. Wow.
Well, you know, some people would say that's a promotion.
I've been both. They're great, both.
But I have no comments. I'm sure you have a co-chair.
Yes, I do. My co-chair may not actually be present right now, and I believe that Representative Fishbein is bouncing back and forth. So with that,
Oh no, it's just me and you.
it is the two of us. With that, I will call the first person on the list to testify, and that's the Attorney General of the state, William Tong. And I believe you may have some people with you when you begin. If you could tell us who you have with you, and if they speak, if they could identify themselves, that would be great. Attorney General, we give everybody 3 minutes, a little bit of leeway since you're the Attorney General, and I'm sure, as you know, having chaired this committee, there will be 1 or 2 questions for you.
Yes.
You may begin. Well,
thank you, Mr. Chairman, and thank you, Chairman Winfield and Ranking Member Senator Kissel. And in absentia, I'll acknowledge Chairman Staffstrom and Ranking Member Representative Fishbein, but I guess my state rep, the Vice Chair, Representative Blumenthal, will have to do as a substitute on the House side. But it's great to be home with all of you on the Judiciary Committee. I miss you all, and I miss you in particular, Deb. And so it's always great to be back with all of my former colleagues here on this committee. Also, I want to acknowledge Nicole Lake, my Chief Counsel and Director of Legislative Affairs. She's with me here this morning, and I'm here this morning to testify in support of Senate Bill 363. And I want to thank the chairs and the ranking members for raising this bill. Again, this is our 3rd go around, and this is what's been colloquially referred to as the Attorney General's Civil Rights Bill. And what this bill does, quite simply, is it says that Connecticut cares deeply about protecting and safeguarding our civil rights. And because we care so much and so deeply about doing that, that you, the legislature, authorize the Attorney General to investigate and sue wrongdoers who violate those rights. It's hard to overstate how important this bill is right now. If you were on the committee with us in 2017, I know Senator Winfield, you and I worked very closely together on this, and also Senator Kissel as well. In early 2017, we saw a spike in hate crimes across Connecticut. We saw swastikas spray painted in Danbury, shots fired on a mosque in Meriden, bomb threats to synagogues in West Hartford and Woodbridge, and the ugliest, most racist word spray painted on a garage door in Stamford. And we answered those attacks and that hate and racism by strengthening our state's hate crimes laws in a far-reaching bill that provides for some of the strongest anti-hate crimes laws in the country. What we did not do when we passed that law is authorize the Attorney General to enforce those laws and to put the considerable weight of my office into protecting people from hate and hate crimes. Now, a few years later, we live in a world that I think we can all agree is riven by hate and extremism. And the FBI director said again, just a few days ago, that racist, white supremacist hate and extremism is one of the FBI's and federal law enforcement's most important law enforcement priorities, one of the biggest threats to our country today, and represents the single largest threat of domestic terrorism. And we've seen the proliferation of hate in Charlottesville, in our nation's capital, on January 6th, and speaking personally, a spike across the country in hate crimes and attacks on Asian Pacific Americans, resulting in violent attacks on people, and some people have lost their lives. So what this bill does is it says that this committee and this legislature and the state now put its full weight behind law enforcement and the enforcement of our civil rights laws, and that you activate me as the state's chief civil law enforcement officer to enforce those laws to the fullest extent.
Mr. Attorney General,
Yep.
if you could summarize, we'll then.
Sure. Let me just say that this puts us in line with our sister states, New York, Massachusetts, Rhode Island, and 22 other states that have civil rights authority reposed in the Attorney General, and they have civil rights divisions. And I'll just wrap up by saying Washington State launched its civil rights division in 2015, New Hampshire in 2017, Virginia just this year, and we hope that Connecticut will do the same. Thank you.
Thank you, Mr. Attorney General. I see a comment or question from your representative.
Thank you, Mr. Chair, and good to see you, Mr. Attorney General. Always great to have a constituent here before the committee, as you know.
Representative, great to see you.
I just wanted to ask you, first of all, I know I'm sure you have more to say on this bill, but I wanted to ask you, first of all, how would this bill change the way your office operates?
So what it would do is it would authorize us to pursue the enforcement of our state's hate crimes laws, and also authorize us specifically and explicitly to protect the civil rights of people here in Connecticut when their civil rights are damaged or infringed by patterns or practices of violations of civil rights. I believe that we have staff in the office right now who are prepared to do that work. I don't expect to need to hire any additional people to do this work, and we're ready to go right now.
Thank you, Mr. Attorney General. And just one more question. In past sessions, well, first of all, I'll just say I support this bill personally, but in past sessions, we have heard criticism that, maybe people saying perhaps that the primary thrust of this bill is maybe symbolic, or, it's making a statement or other similar statements about the bill. And I was wondering if you could address why, first of all, those criticisms, but also just why symbolism and statements can be important, especially in this area.
Well, let me first say it's definitely not symbolic. Across the state right now, people in Connecticut, our constituents, and their civil rights are at risk and are being abrogated. For example, the Islamic Center in New London receiving fake poison in the mail, or hundreds of African-American and Latino and Hispanic residents of public housing in the Hartford area who are denied fair housing because of violations of their civil rights, while federal authorities, sit on their hands. Immigrants, working immigrants in particular in our cities and towns, are subjected to large scale and systemic wage theft. And we see people who have disabilities, who work in, for example, large big box stores, who are reassigned without any protection for their jobs or accommodation. So this is happening right now. It's not symbolic. People are losing their rights, and it's causing damage and harm to them, their employment, their education, their livelihoods, and their families. And a lot of these violations go unremedied because people can't afford lawyers, or their damages individually aren't enough to warrant legal representation in the private sector. And so putting all of them together and having the state attorney general vindicate all of their claims makes more sense. Let me also answer your question about symbolism or making a statement. If your question is whether there's going to be a lot of focus or attention or statements by public officials like you and me and members of this committee about civil rights enforcement and hate crimes law enforcement, of course there will be, because these are matters of great public importance. And whenever something that's really important to all of us in our communities happens, or something should happen, like civil rights enforcement, people are going to talk about it. And frankly, elected officials like you and me are going to talk about it. But that's always the case. We're talking about Eversource all the time, for example. And I don't think anybody on this committee or anyone in our state wants me to lay off of Eversource. You want me to be aggressive. And we talk a lot about the opioid and addiction crisis, for example. And that is something that is the focus of a lot of our statements and our attention. And I'm sure everybody here wants me to be as aggressive as I can possibly be in enforcing the law against wrongdoers in the addiction industry. So yeah, we're going to talk about it. Sure, there are going to be a lot of statements in public discourse, but that's always the case with really important issues.
Thank you, Mr. Attorney General. Really appreciate that testimony. I agree this bill is really significant for the vindication of people's civil rights and human rights here in the state of Connecticut. I agree with you, both from a kind of an instrumental standpoint. But even if this bill were purely symbolic, which I agree it is not, I think it would be important to communities that have been subjected to hate crimes or discrimination. It's important for them to know that we see them, we hear them, and that we view this conduct as unacceptable. And as a result, we are determined to put the Attorney General on the case. So thank you for your aggressive and assertive pursuit of wrongdoers and all of the issues you discussed in your testimony. And I hope we'll be able to give you this authority that can allow you to vindicate Connecticut residents' rights more effectively. Thank you,
Mr. Vice Chairman.
Thank you, Representative Blumenthal. Senator Kasser.
Thank you, Mr. Chair, and thank you, Attorney General, for being truly an Attorney General for the people. I echo my colleague. I am fully supportive of this bill. I just wanted to ask you some more questions about cases which you've been unable to prosecute because you didn't have this authority. You mentioned a number of different areas in which people's individual civil rights have been abrogated, but could you mention perhaps anything about other classes of people, for instance, women or LGBTQ? Are there any other types of situations that you've been unable to pursue?
Yes, in all of those areas, frankly, Senator Kasser, it's hard to catalog all of them because we get so many calls in complaints about abrogation of rights, employment rights, for example, for women and the LGBTQ plus community. And I was very gratified to see this year that the U.S., or actually last year, we lose track of time, right? That the U.S. Supreme Court recognized in the Bostock case that employment protections under Title VII against employment discrimination apply to the LGBTQ plus community. Now, I could take on that battle because as Attorney General, working with my Attorney General colleagues across the country, that was a federal battle in the U.S. Supreme Court. And that is something that I do every day in asserting the state's interests. So that was something that I had the authority to do. I'm not sure that we would have the same authority without this bill to remedy large-scale employment discrimination against the LGBTQ plus community here in Connecticut. And so that's why this bill is important, to make sure that I have authority that, frankly, you probably and most of the people in the state assume I already have. It's also quite unjust, I would say, that if you are a woman and you face employment discrimination and there's a pattern or practice, for example, at your employer or the type of company that you work for, that discriminates against women, for example, based on your parental rights, let's say, that if you walk across the border from where you and I live, and you're in New York, Attorney General Letitia James can bring an investigation and bring suit to vindicate your rights. Or if you live where Senator Kissel lives and you walk across the border into Massachusetts, Attorney General Maura Healey can do the same for you. But in Connecticut, it's not clear that I can. And that's why this legislation is important. And I should say also, in the spirit of full disclosure, Senator Kasser is my senator. So both my representative and my senator have shown up for me today, and I appreciate it.
Oh, well, thank you so much. That's because you show up for us every day. And when I say us, I mean everybody in the state. Just one last question to clarify. So when pursuing large scale, this is your term, large scale injustices, does that mean that you would be able to use a class action suit format, or would these still be individual suits?
So it depends. The answer is that class actions tend to be collections of individual plaintiffs who join together under a procedure allowing for them to combine all their individual claims. The Attorney General doesn't represent individuals. The way that I would be stepping in is in the name of the state of Connecticut, with standing that the state of Connecticut has on its own to vindicate the rights of people in our state. And so that's a long way of saying I have my own basis for asserting claims on behalf of the state of Connecticut, and I don't do that on behalf of individuals.
Thank you so much. Well, again, you have my full support, and thank you for everything you do. Thank you, Mr. Chairman.
Thank you for all that you do.
Thank you, Senator Kasser. Senator Anwar.
Thank you, Mr. Chair. Thank you, Attorney General Tong, for your leadership and clarity of your vision. I again want to thank you for being a leader within the Attorney Generals across the country, for taking on some very important responsibilities and serving as a role model. I wanted to talk a little bit about this bill. Do you think in the last few years this has become urgent issue in our state?
Yeah, it's urgent in our state. It's urgent across the country. And I think one of the challenges is that widespread discrimination and hate crimes often go unreported and unvindicated for the reasons that I have discussed. They go unreported because, for many reasons, but often because these violations happen against people in insular communities, minority communities, urban communities, people that have disproportionately less political power or a platform to make their complaints or to advocate for themselves. They don't have access to legal counsel in the same way that other people of means might, and for fear of retribution, right? And frankly, distrust of public institutions and law enforcement institutions. And so because of that, a lot of these violations and wrongs go unremedied. Also because it may be that the individual harm is not easily quantifiable in terms of dollars and cents for an individual lawyer, or because maybe there isn't, a real good claim or a clear claim for compensatory damages. So we're not talking about money, right? We're talking about requiring somebody to comply with the law and do something as opposed to pay money. And so because of the nature of those claims, you might not be able to get a lawyer or to answer Senator Kasser's question, a class action lawyer to take on your case because it's economically not viable. And that's where the Attorney General has to step in, speaking for the state of Connecticut, speaking for all of you, frankly, and all of us, and asserting the interests of the state to vindicate this harm.
Thank you, Attorney General. The other question was, with some of these hate groups organizing online, do you think your office will, because this is almost like an epidemic level, because
Sure.
it's more than, do we need more resources for your office to be able to address this? Because this is exponentially increasing the last many months or before the elections, and then unfortunately even right now.
So I don't believe we need more resources at the moment, but let me say this. Yes, we are particularly well suited to investigate and bring civil suit. I don't have criminal authority in this area. I have very little criminal authority overall, but we work very closely with the chief state's attorney and the state's attorneys, and not only our local and state law enforcement partners, but our federal partners, the FBI and the U.S. Attorney's Office. But we are built to investigate larger scale violations of law and organizations that systemically break the law. So for example, as you may know, Dr. Anwar, that I am leading the nation's generic drug price fixing case. And I'm also on the executive committee of attorneys general investigating the addiction industry and the opioid crisis. This involves large scale investigations of a lot of people, a lot of documents, a lot of evidence, electronic, hard copy, cell phone records, and it involves the investigation of large organizations. So to the extent that there are hate groups or institutions that perpetrate hate or discrimination, and it's systemic or it's a pattern or practice, I'm particularly well suited to do that work.
And Attorney General, I just want to make a comment. A lot of the people, us elected officials, based on our background, we look like who we are, attached with, which network we are part of, or what our appearance is. We are very privileged. And sometimes when we interact with the people who are less privileged and the ones who are very poorly privileged, if you will, when I interact with them and they know that Attorney General Tong is in control and taking care of one of the most important offices, they feel comforted knowing where you stand and what you stand for. So I cannot thank you enough for being the voice for the people who need a voice. So thank you for your leadership and your entire team for what they do and working. So I want to thank you for that.
Thank you, Dr. Anwar.
Thank you, Senator. Representative Paul.
Thank you, Mr. Chair. Good morning, Mr. Attorney General. It's good to see you. I have a question about, I think you touched on this briefly, but since the onset of the COVID pandemic, have you seen a dramatic rise in hate crimes and vicious attacks against people of Asian origin because of the Kung flu and those sorts of things?
Yeah, we have. I don't have to catalog it for everybody here, but of course, we all know, we've seen, because, leaders in our country have blamed the pandemic on Asian Pacific Americans and referred to it as the China virus or the Kung flu. People have been hurt and people have been killed. Thankfully, nobody's been killed in Connecticut because of that, but out west, a couple of individuals over 80 and 90 years old were pushed down and assaulted, and one died. In New York City, a Filipino-American man was slashed ear to ear on the subway. And, hardly a day goes by that we don't see on the internet some story about an Asian American being targeted. And, one of the challenges, of course, is that as an Asian Pacific American, knowing the history that these attacks on Asian Americans largely go unreported. and they go unremedied because of the history of disempowerment in that community, and because Asian Pacific Americans, have historically in our country not had a significant political footprint or advocacy in their community, and are often invisible when talking about hate crimes and discrimination. And so it's something that happens to Asian Americans right now, but it happens to many different communities every day. And it isn't just based on race, as Senator Kasser said. It can be based on gender or gender identity or sexual orientation and religion. And so there are so many ways in which people's rights are prejudiced that go unremedied.
Well, including, I think, groups for whom we thought perhaps that era had passed. I'm thinking of American Jews, for example. It's sort of unthinkable that the suffering that they are going through, which we thought, World War II might have taken care of. In terms of predicting the next wave or what's on your horizon, do you work with the Southern Poverty Law Center in tracking hate groups in Connecticut?
Yes, and we work closely again with the FBI and the U.S. Attorney's Office and the state police and our state partners. It's hard for me to forecast what the frontier is, except to say that technology-enabled hate is a seminal challenge for all of us. And what we saw on January 6th is an unfortunate reminder of how possible it is in a largely diffuse and disorganized way to get organized really quickly, right? And to perpetrate crimes, in that case, against our very democracy. And so technology and the rise in hate, and of course, in a situation where all of us are feeling vulnerable and just broadly unhappy and under attack by this pandemic, right? And so many people in our state are suffering right now, suffering because they've lost their jobs or their small business, or are at risk of losing one or the other or both. And their children are struggling to learn in schools or in a hybrid model or distance learning. And people, of course, have lost loved ones, thousands in our state, hundreds of thousands across the country. And in this environment, there's just no doubt that can lead to anger and hate and people acting out on their hate and prejudice. So all I can say is we have a lot of work to do. And without this authority, my hands are tied in a lot of circumstances. And I think, I see on social media, but also in the press, and people say, well, why doesn't the Attorney General do something about this? And the answer is, oftentimes I can, but sometimes I can't, because I don't have the affirmative civil rights authority that other AGs have in our sister states.
Thank you for making that distinction. And I think that you're absolutely right. The desperation often gets turned against the other, which is certainly a practice that's been encouraged of late, which hopefully will be a little bit on the decline. My last question is, you made a distinction between civil and criminal. You also made a distinction between adults and juveniles, because I think in our schools, there are a lot of students experiencing hate crime because of their race, ethnicity, gender expression, etc. Is that something that you get involved in, or if not, what advice do you have for school districts on how to deal with this sort of thing?
So it is definitely something that we should all get involved in, right? And Connecticut has been a real leader, not just in strengthening civil rights protections, but in also protecting students from bullying. And with a 15-year-old and a 12-year-old and a 9-year-old, I can tell you it's a really difficult place to be, a school, right? In 2021 America and Connecticut, with phones and social media and sort of instant communication and information. So with this authority, with the Civil Rights Division, I would expect to be involved in those conversations. I would expect all of us to be involved in those conversations. I think if you're municipal officials and you have questions about your approach, you should first consult with your corporation counsel and your legal counsel, because the Attorney General doesn't represent cities and towns, but we're always happy to be part of that conversation and to help people make the right decisions for their communities.
Thank you. Thank you for that. I'm done, Mr. Chair. Thank you.
Thank you, Representative. Representative O'Day.
Thank you very much, Mr. Chairman. Good to see you, Mr. Attorney General.
Good to see you, Representative, and my neighbor.
As you may recall, I was the lone R supporting similar legislation in the past. I'm inclined to help out and support it again if we can talk further on it with some concerns. For example, lines 6 through 8 state that no information obtained pursuant to the provisions of this subsection may be used in a criminal proceeding. And that was brought up by some of my colleagues on my side of the aisle as a concern. The subpoena power in the criminal context is limited, if not completely. So, and the sharing of information by the AG's office with the state's attorney's office was brought up as a concern.
Yes.
I know you had addressed this previously, but if you could just state how would you prevent that from happening going forward?
Yeah, we keep our information in the strictest of confidence and protect the results of our investigation, the information that we glean very, very carefully and very protectively. And if we're not permitted to disclose it, we don't. And that has been the case in the Attorney General's office well before I became Attorney General. And we're bound by law to do that. This provision in 6 through 8 was due in part to your input in the last go around. I should note that this bill is identical in all material respects to the House bill that passed with your support. Thank you very much. A couple of years ago. And also at the time, Ranking Member Abimbis also provided a lot of feedback and suggestions. And so the bottom line is this: if we, in our investigation, collect information, we cannot affirmatively turn that over to the state's attorney. And this makes that clear.
Thank you. You had mentioned that if this does not pass, your hands are tied in a lot of circumstances without this legislation. Can you give us an example of if we pass this, what you would be able to investigate, whereas now you cannot?
So the two examples I would point to it, and I've given a number today. For example, hate crimes enforcement. It's not clear from our 2017 hate crimes law that the Attorney General has the authority to step in the name of the state of Connecticut to bring civil actions against people for violations of those laws. Number one, all the penalties in that law, or almost all of them, are criminal in nature. And this would enable us to bring investigations and cases to enforce those hate crimes laws on a civil basis. The second thing is the example I gave of disabled people, for example, that work in a big box store. We came across a situation where people who had disabilities were working in a big box store as greeters. So when you walk in, right, they say hello, they direct you to the right aisle, and that big box store, which was part of a national chain, decided it didn't want to have greeters anymore. And it was hard for them, because of the disabilities, to find another role for their employees. So they didn't find one for them. They didn't accommodate them. They didn't take into account their individual civil rights, and instead, these people either lost their jobs or were unable to find anything else that was a suitable replacement for the job they'd already been doing. And so that situation at least demands an investigation, right, into what happened there and whether people were discriminated against because of their disability and whether there was an accommodation that could be had. And if we were to find that there was affirmative discrimination, then we could bring suit.
I will agree too that the shocking increase that thankfully Connecticut has escaped of the hate crimes, whether it's far right or far left. I note that the attacks on the elderly in New York City, just out of the blue, see videos of people walking up and tackling them. It's extremely disturbing. The example of, as a Roman Catholic, the example of people going into churches and screaming and threatening in the Catholic Church. Those are things that you would also, it's not just one group you're protecting everyone that's subjected to a hate crime, whether it's from the far right or far left, correct?
Correct. It's everyone. And as you know, Representative O'Day, as a very experienced practitioner, we bring cases when we have a cause of action or causes of action and good facts, and witnesses and documents. And, I can tell you that I'm going to be aggressive on behalf of everybody. And if we have good claims and good facts, chances are we're going to bring those cases.
Thank you very much, Mr. Attorney General. Thank you very much for your service, not only in the House, but in the past, but what you're doing in the Attorney General's office. Greatly appreciate it. Thank you, Mr. Chairman.
Thank you, Representative Curry.
Thank you, Mr. Chairman. Attorney General, it's a pleasure to see you, as always. I'm just going to shift gears a little bit. On the agenda today, we also have House Bill 6321, which is the Parentage Act. And I just want to say thank you to you and your office for your partnership and all the work that you have all done on this to help us kind of get this moved along. I was wondering if you had any comments on the Parentage Act.
Let me just say, first of all, Representative Curry, you look great. And it's great to see you.
Thank you.
Let me say, yeah, this is a really important bill. I think it's required by law. Frankly, to me, it's sort of a no-brainer. Connecticut is very clear. Its civil rights law is very clear that we protect all people from discrimination, including people in the LGBTQ plus community. And Connecticut's laws relating to parenting and parentage and parental rights are not up to date and do not conform with those laws, and do not recognize the great diversity of families that we have across Connecticut, including same-sex couples, where one parent, for example, may be the biological parent and the other parent may not be, or in cases of assisted surrogacy, I guess is the best word. Assisted parentage. In those cases, in surrogacy cases, our law is not up to date either. So we need to make sure that it is, so that everybody in our state, that the law requires that we respect and protect and defend, and that we honor and vindicate their civil rights, that their civil rights are respected in all ways, including in their relationship with their children, which, when we talk about civil rights, we really focus on people and their personal rights and their most important relationships, right? With each other, with their community, with their employer, with their school. There's no more important relationship than a parent to a child. And that's why, is it 6321, Representative?
Yeah.
It's really important that we pass that bill.
Thank you very much. I appreciate those comments and the office's support. And thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Are there other comments or questions from members of the committee? Other comments or questions? I do not see any, Mr. Attorney General, so I would like to thank you for joining us today. I just want to make sure. So Nicole Lake was with you. Was Mr. Perry supposed to be with you? He signed up as well. Is he doing separate?
Mr. Perry is not with us today. It was just me and Nicole. I thought that I would step up and do all the work this morning.
Got it. I'm just checking because he's on the list right next to you. So, all right. Well, I think that is it for you today.
Thank you, Mr. Chairman.
A little
Thank
faster
you,
than
Attorney
normal.
General. Thank you, Nicole.
Mr. Ranking Member, nice to see you.
Always a pleasure.
Hope to see you all in person soon. Get your
Enjoy it.
shots. Get your shots.
Enjoy the rest of your day. So I'm just going to go down the list, the next couple of people. We do have Josh Perry next, but I believe he would have been associated with the Attorney General. We have Judge Streetkafalis and then Carlos Moreno. I see that the judge is in.
Good morning.
Good morning. You have your 3 minutes. You may begin.
Thank you, Senator Winfield. Representative Staffstrom in absentia, Senator Kissel. Representative Fishbein, I don't believe is on the meeting yet as well, and honorable members of the Judiciary Committee. I'm Judge Beverly Strike Kafalis, the Probate Court Administrator for the state of Connecticut. Thank you for the opportunity this morning to testify in support of House Bill 6321, an act concerning adoption and implementation of the Connecticut Parentage Act. Just about a year ago, I testified regarding this bill, supporting the concepts, but noting it was a very complex bill and that I had committed a year ago to continue to work with the proponents of the legislation to address any concerns the probate court system had regarding this bill. I'm happy to say today that I am in support of the bill as drafted. The proponents and I and many other stakeholders have been working extensively over the past year to review the complexities of what is very critical need to modernize Connecticut's parentage laws. So as I said, I'm pleased to sit here today in support of this legislation. I would note that many of the proposed legislative changes are integral to the probate court system procedures and have a significant impact on many other non-parentage related laws, such as inheritance rights, notice of court proceedings, and guardianships. A very critical component of the work of the probate courts addresses guardianships of minor children. In the probate court system, we have appointed over 7,000 guardianships for children in the state of Connecticut, and also have approved and adjudicated a number of adoptions. Adoptions that under this proposed legislation would no longer be necessary because the constitutional rights of those parents are addressed and now given legal status. And that is critical, not just for the parents, but importantly for these children whose rights are jeopardized and are left vulnerable. What is important in the legislation as well is that the uncertainties and the injustices faced by parents in parent-child relationships with this bill will no longer be jeopardized because of genetics, gender, sexual orientation, or marital status. It does serve a critical role in ensuring and protecting those constitutional rights. And we have had the honor and the privilege to work with the proponents in the past year to address jurisdictional and technical matters to ensure these constitutional protections. I'm happy to answer any questions, and I would just again like to thank all of the stakeholders that my office worked with and the proponents. It's been a very successful and collaborative endeavor that I was very pleased to participate in. So thank you. And Representative Curry, great to see you as well.
Thank you. And Representative Curry has the first comment or question.
Mr. Chairman, good morning, Your Honor. Pleasure to see you. Just want to thank you and your staff for your commitment to really getting this to where it is today. And I know you made that commitment very clear a year ago, and the work that you and Melissa and everybody else have done has just been outstanding, and we really truly appreciate that. And just so folks have a sense of the work that's kind of being done behind the scenes, your office and has worked in coordination with also the judicial branch to ensure that language is appropriate and everyone's staying in their own lane, essentially, correct?
That is correct. We did have some collaborative meetings jointly with the judicial branch. And as you know, Professor Najim, who I'm sure he'll testify to, and my written testimony also reflects that we did work with the judicial branch so that we did make sure that there was no conflict over jurisdictional issues and technical challenges that the bill might otherwise present.
Excellent. Thank you very much. And again, I look forward to continuing this conversation and any work we may have in the future. Thank you, Mr. Chairman.
Thank you, Representative.
Thank you, Representative. Are there comments or questions from other members of the committee? Comments or questions? Seeing none, thank you for joining us this morning, Judge, and I hope you have a great day.
Thank you, Senator. Have a great day as well, everyone.
Next in line, we have Douglas Najane, Kathy Paniotti, and Patricia Garcia. Is Douglas Najane in?
Yes, I'm here.
How are you? You may begin. You have 3 minutes.
Thank you. Thank you to Chairs Winfield and Staffstrom, Vice Chairs Kasser and Blumenthal, Ranking Members Kissel and Fishbein, and members of the Judiciary Committee for allowing me to testify in support of Race Bill 6321, the Connecticut Parentage Act. Thank you also to Representative Curry and all of the co-sponsors of the bill. My name is Doug Najame. I grew up in Torrington, where much of my family still lives, and I now reside in Guilford with my husband and our 2-year-old son. I'm the Ann Urosky Professor of Law at Yale Law School, where I teach in the areas of family law and constitutional law, and I hold a secondary faculty appointment at the Yale Child Study Center, where I work on law and child development. My primary research involves parentage, the legal status of the parent-child relationship. Parentage gives rise to rights such as custody and decision-making, and responsibilities such as financial support. Parentage is critical to children's welfare. We know that children do best when their relationships to their parents are legally recognized and secure. Yet many children in Connecticut are deprived of that security. This is because the law fails to treat their parents as legal parents. Let me provide just a few examples. Connecticut statutes regulating the marital presumption of parentage, as well as assisted reproduction, include only husband and wife. Virtually all federal and state courts, including the US Supreme Court, have found statutes like ours unconstitutional. Connecticut also refuses to treat both women in an unmarried same-sex couple as legal parents when one is the birth mother and the other is the genetic mother. This too, courts have found unconstitutional. Same-sex couples raising children necessarily include a non-genetic parent, but many other children in our state are also being raised by a non-biological parent. Yet, unlike every other New England state, Connecticut offers no protection to the child of an unmarried non-biological parent, even though the state is obligated by law to recognize LGBTQ parents and to provide equal treatment to non-marital children. The Connecticut Parentage Act solves the problems in our parentage law. It satisfies constitutional requirements. It reflects the diversity of families in our state. It protects children who are vulnerable under current law. It brings order to an area where there is uncertainty. It updates law that is outdated, and it reflects best practices. The bill provides clear and accessible paths to parentage without respect to a child's circumstances of birth or the gender, sexual orientation, or marital status of the child's parents. It regulates married parents so as to include same-sex couples. It treats intended parents who engage in assisted reproduction as legal parents. It provides parentage protections to children of non-biological parents. It allows same-sex couples, just like different sex couples, to sign acknowledgements of parentage, a simple administrative device, so that they're treated as legal parents at the moment of their child's birth, to not undergo the lengthy adoption process that Judge Treat Kafalas discussed. It regulates surrogacy, a practice the state has long permitted, but has not adequately addressed by statute. The bill is based on the Uniform Parentage Act developed by the Nonpartisan Uniform Law Commission.
Mr. Najane?
Yep.
If you could summarize.
I
Thank
served as an observer to the UPA, and I'm on the National Enactment Committee. I have tailored the bill to Connecticut laws and practices, and it reflects work with all relevant stakeholders, including the courts, and is supported by a broad coalition. And I'm happy to answer any questions. Thank you.
Thank you, Mr. Nijan. Representative Curry?
Thank you, Mr. Chairman. Doug, nice to see you. Just want to first off, thank you for the work that you and your students have done. I think, you know, for my colleagues, over the last 6+ years in the legislature, I have never had or worked with anybody who has worked a bill so hard for so long to get it to where it is today, and to build a coalition to the level that they have, as well as bringing in all of the partners and the essential people to ensure that all those T's are crossed and those I's are dotted. This has just been a tremendous amount of work, and I just want to thank you for that, and all of your partners as well. Can you talk a little bit about the concerns that kind of came up along this process, and have they all been addressed?
Yes, so thank you, Representative Curry, and also we're so grateful for what you've done to help us with this legislation. So there have been concerns that we've worked out with the relevant stakeholders, including agencies, the courts, and practicing lawyers in the state. I can just reference a few and give you a sense of what's changed from last year's bill that was before this committee. One concern was with additions to Connecticut law, things that other states have long had, but that would be new to Connecticut law. One is called a presumption of parentage. We have a common law tradition in the state that when a married woman gives birth to a child, we presume that her husband is the legal father of that child. That presumption is not codified in our statutes, but should be. And so we are codifying presumptions of parentage, and to meet our obligations to treat non-marital children equally to marital children, which has been a constitutional requirement since the late 1960s. We are also including the non-marital presumption of parentage, which would allow a person to establish their parentage based on living with the other parent and holding the child out for the first 2 years of the child's life as their child. The concern that we addressed with practitioners and with the courts was about how to establish and be certain about that parentage context, since there is not a marriage license to actually show. And we, as compared to last year's bill, resolved with the judicial branch and the probate court, as well as with the Department of Children and Families and the Assistant Attorneys General representing DCF, to require that an individual who satisfies the non-marital presumption of parentage must establish their parentage formally, either through an acknowledgement of parentage or through a court adjudication, so that there is no uncertainty about the person's status. And let me just say, an acknowledgement of parentage is something that we're required to have under federal law. It is a simple administrative device that hospitals give when a woman gives birth. And right now, it is the most common way that the parentage of non-marital children is established in the United States and in Connecticut. And what we would do in our bill is extend the acknowledgement of parentage to same-sex couples and other couples using assisted reproduction, so that they can establish their parentage at the moment of their child's birth. So that if one of the parents, if the birth parent is incapacitated, the second parent can make decisions, so that they don't have to spend thousands of dollars adopting their own child. And under federal law, the acknowledgement of parentage is required to get full faith and credit from other states. And so that is why same-sex couples in our state would no longer need to adopt their own children. So as Judge Street-Kefala so nicely said, we have worked with the courts to make sure that this system is easily administered and that they feel they have the certainty about parentage. That's what we're trying to do, is bring efficiency and certainty here. And the changes that were made from last year around the presumptions of parentage are accomplishing that goal.
And so to just kind of further discuss the federal protections, basically, so now parents don't need to worry about crossing state lines, and essentially will have the same rights that they would otherwise here in the state of Connecticut, correct?
Yes, so married same-sex couples in Connecticut while they can both be put on the birth certificate right now, birth certificates are evidence of parentage, but they do not establish parentage. And the birth certificate does not get full faith and credit when it moves across state lines. So that's why same-sex couples are going to the probate court and adopting their own children, because the adoption is a judgment that under the federal constitution gets full faith and credit. Because federal law requires that acknowledgements of parentage get full faith and credit, couples would now be able to sign an acknowledgement of parentage, the birth mother and her partner, to establish parentage and be confident when they move across state lines that their parentage will be recognized. But it also offers incredibly important protections within the state of Connecticut, because right now, an unmarried same-sex couple cannot establish parentage for both of them without doing an adoption. And so this would allow them to establish parentage and, consistent with our constitutional tradition, not require that a child have married parents in order to have two parents.
Thank you for that. And I think you've answered about 3 or 4 questions that I had within your responses already. And for my colleagues, if when you pull this up, this is 127 pages. And as you can hear from Professor Nijane, that this is pretty wonky. So, if you have any questions as this moves along, please don't hesitate to reach out, and we'd be happy to have further discussions and meet with anyone who wants to kind of go over this a little bit more in depth. I really appreciate, again, you coming out today and all of the work that you have done on this piece of legislation. Thank you.
Thank you, Representative Curry.
Thank you, Representative. Representative Porter.
Thank you, Mr. Chair. Just a quick question, and listening to the conversation the last few minutes, I'm just wondering, has there been any consideration given? You said that the acknowledgement of parentage with married couples, the husband would automatically be assumed the parent. Is that correct?
That is correct under current law, yes, and under our bill.
Okay, and I mean, the only thing that it draws, and I've had this conversation with several people, it makes me wonder, has there been any thought given to the fact that there are instances when that is not the case and how that impacts the child later on down the road?
Yes, so thank you, Representative Porter, for that question. Just to be clear, you're saying in cases in which a married woman gives birth to a child, but the husband is not the biological father of the child, and there is another man who actually is the person who's going to be the parent of the child.
That is correct.
Yes. So now we're really getting into the weeds, but let me say this has been something that we have worked on very carefully. So right now in Connecticut, the Department of Public Health allows a woman who gives birth to a child, if she is married and her husband is not the genetic father of the child, she is able to do an acknowledgement of parentage with the genetic father to establish her parentage. Connecticut is distinctive in that respect, but we have a statute that provides authority for the birth mother to autonomously decide that the genetic father can be the legal parent of the child and not her husband. And in those scenarios, it's a scenario where applying the presumption to the marital father doesn't make sense because she's actually going to parent the child with another man who is the genetic father. And so we have worked hard with the Department of Public Health and the judicial branch to preserve that in existing Connecticut law. What we have also done that is not in existing Connecticut law, but should be, is to provide a clear guidance about what happens if after the fact, so at the time of birth, the married woman and her husband both go on the child's birth certificate, but after the fact, later on, there is the discovery that he's not the genetic father and there's another man who is the genetic father. And just to be clear, we are only talking about cases in which the child is conceived through sexual intercourse and not through assisted reproduction. But in that case, our bill provides for the ability to challenge the presumption of parentage, the marital presumption, based on the fact that the man is not the genetic father of the child. And we have ordinarily a 2-year window by which a presumption of parentage can be challenged. The reason for doing that is because the assumption is if a man has been parenting the child for 2 years, there's a parent-child relationship such that it would be not in the best interest of the child to destroy that relationship. But we also provide circumstances under which a challenge after that period would be allowed, particularly in cases in where the man is not the genetic father, where he has not resided with the child and held the child out as his child, or where the man who is the genetic father did not know at the time of birth that he was the genetic father, but discovers that he was, and within 1 year of such discovery, takes steps to actually establish his parentage. And so I really appreciate that question, because this is a scenario that, while it doesn't arise very often, it does arise, and it arises in every state, and every state has tried to deal with this. And we think it's important for our legislation to actually be clear about how courts are to address these situations, and to think about the very contingencies that might exist when you have a situation in which there's two men who might have claims to parentage, one based on marriage and one based on genetics. And so our bill provides the guidance on that, while also preserving existing practice around the acknowledgement.
Thank you for that response. And I'm glad, and I think I understood that even past the 2 years, because there's oftentimes several years and even decades, unfortunately, where children find out that who they thought was their father their entire life is not actually their biological father. Has there been any thought given to just when children are born, just making sure that who is being put on the birth certificate as the father is actually the father?
So thank you, Representative Porter. So under federal law, states are not permitted to require genetic testing at birth for non-marital children. And so there is no state in the country right now that requires genetic testing for a woman who gives birth to sign an acknowledgement of parentage with the alleged father in order to establish parentage. The acknowledgement of parentage done by unmarried parents in Connecticut includes provisions informing the both the birth mother and the purported father that they have the right to genetic testing, and that they should not sign the acknowledgement attesting to the fact that they're a genetic father if they have a doubt that they're a genetic father. But we do know that individuals sign these acknowledgements and at some later point might discover that they are not the genetic father of the child. Under federal law, states are not allowed to require genetic testing. They just have to offer genetic testing. And we do not disturb any of the provisions regarding federal law in that respect. I will say one important thing that we do is provide, and this was also done in consultation with the family law section, and with the chief family support magistrate, that we provide the opportunity for a man who discovers that he is a genetic father at some later point to be able to establish a parent-child relationship, even though there was an acknowledgement signed between the birth mother and another man. Under federal law, and again, this is very much in the weeds, so I apologize to others. Under federal law, acknowledgements of parentage can only be challenged after the 60-day rescission period based on fraud, duress, or material mistake of fact. It is a very high standard in which the mere fact that one is not a biological parent does not give rise to fraud, an allegation of fraud. And so you can't undo the acknowledgement of parentage under the vast majority of circumstances. But what our bill does, and what other states have now done, is allow a man who discovers later he is the genetic father to be able to try to establish his parentage without having to challenge the acknowledgement of parentage signed by another man with the birth mother.
Thank you for that. And I was actually talking about only for married folks, because there is a presumption that the husband is the child's father. I wasn't saying for people that were unmarried, but we can have this conversation offline, because I know other people are waiting to ask questions, but I do have some concerns around that. So if we could talk about, the father being the husband and the presumption being made that, acknowledging him as the father when he may not be. Thank you, Mr. Chair.
Thank you, Representative. Senator Kasser.
Thank you so much, Mr. Chair, and thank you, Professor. I just wanted to ask you, what other states, particularly in our region, have a similar law to this? Is Connecticut an outlier for not having it?
Yes, thank you, Senator Kasser. We are an outlier, especially given our leading role in protecting children and families and in promoting LGBTQ equality. It is striking that we're such an outlier on this. Every other New England state has reformed their parentage laws to protect children of same-sex couples, as well as parents who engage in assisted reproduction to have children. And every other New England state has pathways to parentage for unmarried non-biological parents. Rhode Island and Vermont have both passed the Parentage Act, the Uniform Parentage Act. Maine's law, which was reformed in 2015, is reflected in the Uniform Parentage Act. The drafters look to Maine law as an example. Massachusetts has both a non-marital presumption of parentage and de facto parentage protections. New Hampshire has recently reformed its parentage laws and also has long had a non-marital presumption of parentage. And in the midst of the pandemic, New York State passed a comprehensive parentage overhaul that codifies some existing law there and provides additional protections to non-biological parents who engage in assisted reproduction. And so nationwide, but also in our region, Connecticut is an extreme outlier.
Thank you so much. And I know a lot of the focus has been on the rights of parents that would be established, but wouldn't this bill also establish the rights of children to have legal relationships with their parents? Can you talk about the impact on children of not having legally established parentage rights?
Yes, thank you, Senator Kasser. In the late 1960s, the US Supreme Court actually recognized that non-marital children of unmarried parents, have an equal protection right to their parental relationships being recognized. And since then, states across the country have continuously reformed their parentage laws to protect children's rights to a parent-child relationship, because so much comes from that. The child is able to have someone who is authorized to make decisions for them. The child is able to get health insurance through the legal parent. The child has parents who are financially obligated to support them. And as Judge Street-Kafalis told us, it also matters for purposes of inheritance. And a lot of the early Supreme Court cases were about the right of children to inherit from their parent. So children's rights are protected through this legislation. And my colleagues at the Yale Child Study Center, as well as pediatricians at Children's Hospital and doctors at Yale New Haven, are supporting the legislation because they know that from the child's perspective, the importance of the parent-child relationship doesn't spring from marital status of the parents or biology or whether they were conceived through assisted reproduction, but actually is about who's there being a parent to that child, who's there on a day-to-day basis. And there are too many children in this state that do not have the security of a parent-child relationship with the person who they see as their parent.
Thank you so much. And in addition, I would imagine in addition to those financial rights and the right to inherit, there's also the priceless right to continue a relationship. So a parent-child relationship. So in the event that the two adults dissolve their relationship, the child would still have the right to continue to see and continue his or her relationship with the parent, even though the two adults are no longer in a relationship, correct?
Yes, Senator Kasser, and actually some courts in other states have reasoned in exactly that way. When an unmarried couple with a non-biological parent breaks up and the biological parent shuts the non-biological parent out of the child's life, the child, in the famous New York case on this, the court appointed a child to represent an attorney to represent the child, which was unusual in that situation. And the child's attorney brought the case to the High Court of New York saying this child has a right to maintain this relationship with their parent. and the New York High Court agreed with that. And our bill would codify that kind of right for a child.
Thank you so much. So there's really a tremendous emotional impact, lifelong impact to children, in addition to financial, responsibility that would come from establishing parentage. But I just wanted to highlight those other very, very significant benefits to children. So thank you so much, Professor, and thank you, Mr. Chair.
Thank you, Senator.
Thank you, Senator. Oh, sorry. Thank you, Senator Kasser. Representative Blumenthal, followed by Representative Howard.
Thank you, Mr. Chair. Good morning, Professor Najim. Good to see you.
You too.
I have more of a comment than a question, so I hope you'll forgive me. First of all, I just want to say thank you to you and all your students for all the tireless work you've put into this process. And thank you in addition to your testimony, your oral testimony today, for your written testimony, which I encourage all my colleagues to read if you have any questions about the bill. To my colleagues, in case you can't tell, if you have a question about this bill, Professor Najim has an answer. So I would encourage you to read his testimony. If you have questions later, I know he's happy to talk to you. And I want to say a special thank you to Representative Curry for his leadership on this bill as well. I guess my comment, in addition to what I've just said, is that I agree with you. I think our current parentage law is unconstitutional, both based on our federal constitution, but also based on our state constitution. And it is just a matter of time before a court strikes it down. And courts, as you know, have far fewer tools to fix laws like this than legislatures do. The law that you have helped put together deals with all these issues with a scalpel, where a court would have to deal with them with a meat hammer. And so I would just say to my colleagues, if you are wondering whether now is the time to make this fix, there is no time to waste, not only because it's the right thing to do, and I believe it is, but also because we have the tools to fix this problem, and it is just a matter of time before our current law gets struck down. So thank you, Professor. Thanks, Jeff, for all your leadership, and thank you, Mr. Chair.
Thank you, Representative Blumenthal.
Thank you, Representative Blumenthal. Representative Howard.
Good morning, Professor. How are you?
Good. Thank you.
Thanks for all your work on this. Thanks for being here today. I do just want to let you and my colleagues know, many of my colleagues know, that I work with a lot of children in my district, and I know that kids need to know the world's not going to fall apart tomorrow. So having that sort of confidence, as you and Senator Kasser so eloquently laid out, is really important. Some of you got into constitutionality, but I want to ask you a couple of questions that are important to me, important to people in my district, so just so we can lay this out to those of us who don't study constitutional law quite so as well as others. I'm married to a woman. If she were to be artificially inseminated and have a child, who's that child's legal father?
You would
today.
be.
I would be today. What
Yeah.
steps do I have to take to ensure that I'm that child's legal father when we leave the state of Connecticut?
Nothing.
Okay, so if I had two friends that were both female and both married, and one of them was artificially inseminated, would the same be true for her wife?
No, it would not.
Would this law fix that?
Yes, it would.
Okay, that's an important point. And based on all your extensive research on this, Professor Najim, is there anything that you think this, and you've looked at other states and what they're doing, and it's clear that you've gone, to use your words, into the weed, gotten into the intricacies of this, right down the minutia, all the ifs, thens, buts, etc. The legislation that we have before us, is there anything that you think needs to be changed or addressed further?
No, I don't. And let me just say, Representative Howard, that because this is a change to Connecticut law, often we hear concerns that are raised. And I can tell you that based on my research regarding every other state in the country that has laws like what we would be doing, we've done what is the best practice in this bill and have anticipated concerns and really have addressed whatever might come up, and don't have any evidence of some of the issues that folks might fear actually arising based on what other states are doing.
So all of your research on that, you're comfortable with the legislation as it sits before us today?
That's correct.
All right, and thank you for your answers. And I do just want to echo my colleague, Representative Blumenthal. I've taken the opportunity, as you know, to speak with you offline, ask you questions to get an understanding of this. And I want to thank you for being so responsive and taking the time to make sure that somebody who doesn't quite have the extensive knowledge on the topic that you do can understand it. So thank you for that. And thank you, Mr. Chairman.
Thank you so much, Representative Howard.
Thank you, Representative Howard. Are there comments or questions from other members of the committee? Comments or questions? Seeing none, Mr. Najim, thank you for joining us today and offering your expert testimony. Hope you have a great day.
Thank you, Senator Winfield.
Next, we will hear from Kathy Paniotti, followed by Representative McCarthy-Vey, followed by Patricia Garcia. Kathy Paniotti. Kathy Paniotti. Okay. Representative McCarthy-Vey, are you in?
Thank you, Mr. Chair, and I'm having technical difficulties today. If you can give me just one moment, can you hear me?
I can hear you, and I can see you as well.
Okay, wonderful. Well, thank you so much, Chairs Senator Winfield and Representative Stastrom, Vice Chair Senator Kasser and Representative Blumenthal, and Ranking Member Senator Kissel and Representative Fishbein, and esteemed members of the Judiciary Committee. I regret that I wasn't able to be with you to hear Professor Najim's testimony today, but I also am here today in support of proposed Bill 6321, an act concerning the adoption and implementation of the Connecticut Parentage Act. A few numbers for you to consider. 127 pages, the bill itself. 2.5 years, the time Attorney Najim spent working on this bill. 6, at least, state agencies, departments, or branches involved in drafting the bill. 3 sections of the Connecticut Bar Association who voted to support the bill. 30 plus supporting agencies, practices, or entities cited in Attorney Najim's testimony. And 9 pages of testimony, and I did hear Representative Blumenthal say, if you haven't had a chance to reference it. Professor Najim, together with Polly Crozier at GLAD and many others, has led Connecticut's efforts to update Connecticut's parentage laws, and I would concur with Representative Curry's leadership. He's clearly articulated the legal reasoning for these changes, and I would like to just concur that our LGBTQ parents deserve equal protection under the law, which our Constitution guarantees and courts have affirmed. Unmarried, non-biological parents, families who utilize assisted reproduction, and those who participate in the surrogacy process all have a right to a clear path to parentage and assurance under the law that these rights are secure. While Professor Najim heavily emphasizes the legal and judicial framework for the bill, he also notes the importance of attachment in parenting. An infant does not care whether the law has recognized their parent legally. She knows her parent as the attachment figure who provides a secure base which allows her to develop. These attachments provide a child the safety and security needed to develop, explore, and relate. The child and his parents will benefit from the security and certainty that this change in the law will provide. Too many of our LGBTQ friends, family, and neighbors have struggled with the fear and uncertainty created by the law as it is currently constructed. These clarifications are particularly important for the most impactful and vulnerable times in a family's life: birth, serious illness, death, divorce, separation, or marriage. It's time for Connecticut to join every other New England state and states around the country in updating our parentage laws. Let's equally and legally protect all children and parents' relationships with one another. Thank you, Mr. Chair.
Thank you, Representative. Are there comments or questions from members of the committee? Are there comments or questions? I do not see any. I want to thank you. I know you put in some work on this as well. I want to thank you for that work and thank you for joining us to offer your testimony today, Representative.
Thank you, and I'm glad that Attorney Najim was able to really cover all the questions. Have a wonderful day.
You too. I see that Kathy Paniotti's name shows up. Is Ms. Paniotti able to unmute and testify?
Hi, yes, can you hear me?
I can hear you. You have 3 minutes.
Hi, thank you, Mr. Chairman, for coming back to me. thank you, Representative Staffstrom and the rest of the committee for listening. My name is Kathy Pagnotti. I've been a registered nurse for 32 years. I presently work as the third-party manager at the Center for Advanced Reproductive Services, and I have an extensive amount of experience in labor and delivery as well. I could never say things as eloquently or as beautifully as Professor Najim, but I'd like to put a real life picture on this scenario. So I now work with many individuals who need assisted reproductive technology, particularly third-party members, to conceive and have a child. The way this works is that a same-sex female couple comes in. They need to find a third-party, a sperm donor. They spend thousands of dollars, thousands to spend hundreds of hours. They take medications. They may have a very, very deliberate, perhaps the most deliberate path to parenthood that a person could have. They put everything in this financially, psychologically, medically. To become pregnant, they can't be happy though. Second trimester, they contact us again, and we write letters and we send medical records proving that they indeed are the parents, and proving with legal testimony that they are the parents of their own child. Because at the end of this, in the delivery room, they're going to be asked who the parents are. And if they have not put in the legal hours prior to that birth to establish themselves as parents, they're subjected to the people in the delivery room, to the registrar, to what their knowledge of the law, or presently the lack of law, in relation to third-party reproduction. They need to prove themselves after putting everything they have into this process as parents. And they're subjected to the mood sometimes of the registrar, the mood sometimes of the judge, as to whether or not they can be legal parents to their children that they so deliberately planned. On the flip side of that, when I had my children in a more traditional manner, and when I was a labor and delivery room nurse, they said, "Are you the mother?" Obviously, I'm the mother. "Are you the father?" The person standing next to me said yes. And that was all we had to prove. If I go on vacation, I can legally represent my children. I can consent to medical treatment. These poor women can't do that. They're scared to go on vacation. They're scared to be in the car with their child if they're not legally on the birth certificate. It's terrible. I probably sound emotional because I am. I come to love our patients, and they simply do not have the rights that a majority of us do. The scenario in the delivery room is awful. I have been witness to a couple, a heterosexual couple, standing in the delivery room.
Just so you know, you may summarize, but I'm just letting you know your time has elapsed.
Okay, my time is done. Please support this bill. That's all.
All right, that was great. Are there comments or questions from members of the committee? Comments or questions? I don't see any, but I want to thank you for joining us today. And yes, it is emotional, and it is perfectly fine that we respond as human beings to emotional subjects. Have a great day.
Thank you so much.
All right. Next, we have Patricia Garcia, followed by Casey Jacob and Sana Shah. Patricia Garcia, you may unmute and have your 3 minutes.
Thank you. Good morning, members of the Joint Committee on Judiciary. My name is Dr. Patricia Garcia, and I'm a pediatrician from Farmington, Connecticut. I am testifying in support of Bill number 6321, an act concerning the adoption and implementation of the Connecticut Parentage Act. As a pediatrician, I have the privilege of witnessing the special bond between children and their parents, and appreciate this bond's importance, both emotional and legal, in times of medical crisis. This understanding has only been strengthened by my own experience of becoming a parent. My husband and I wanted to build a family, but we struggled with infertility for 5 years before I finally became pregnant through donation. Our doctor helped us review the legal implications of assisted reproduction, which clearly defined that my husband would be our son's legal father. We were overjoyed to welcome our son in July of 2019. But unfortunately, the morning after I was discharged from the hospital, I had to be readmitted because of an infection. I was heartbroken to be separated from my newborn. And as a doctor, I understood how serious my condition could be, and I was terrified. But one thing I didn't have to worry about was my 3-day-old son's well-being, because he was safe, at home, being cared for by his father. My husband was a hero. He took care of a newborn by himself, and he came to speak to my doctors multiple times a day because I was too sick to advocate for myself. I didn't understand at the time that our family only had this privilege because my husband and I were married. If we had been unmarried, my husband would have been a legal stranger to our baby and would have been powerless to help his family in our most vulnerable time of need. I was devastated to learn that not all families created through assisted reproduction have the same legal security that we did, because our current parentage statutes exclude same-sex and unmarried couples. I want to live in a state where my neighbors and my patients do not need to adopt their own children in order to have the security of legal parentage. No family should have to deal with the vulnerability of insecure parentage, particularly during a medical emergency. Every child in Connecticut deserves the same security and protections that my son had, regardless of the marital status, gender, or sexual orientation of their parents. And for this reason, I urge you all to support Bill 6321. Thank you.
Thank you, Dr. Garcia. There are comments or questions from members of the committee. Representative Curry.
Thank you, Mr. Chairman. Good morning, Doctor. I just want to say thank you for lending your professional, but mostly your personal support of this legislation, and really highlighting just why this is so important that we get this done for those who don't have those protections that you are so simply afforded. So really appreciate you coming up today and sharing your story. Thank you, Mr. Chairman.
Thank you, Representative. Are there other comments or questions from members of the committee? Other comments or questions? I do not see any. I want to thank you for joining us and offering your testimony and sharing your story with us. It's important. Have a great day.
Thank you.
Thank you. Next, we will hear from Sana Shah. Sana Shah in.
Dear Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and esteemed members of the Judiciary Committee. My name is Sana Shah, and I'm testifying today on behalf of Connecticut Voices for Children. Connecticut Voices for Children supports House Bill 6321, an act concerning adoption and implementation of the Connecticut Parentage Act. Currently, Connecticut law leaves thousands of families vulnerable due to the lack of access to legal parentage for all children. Connecticut is the only New England state without protections or paths to parentage for non-biological parents to establish their legal parent-child relationship. As part of the We Care Coalition, Connecticut Voices for Children is a proponent of the critical stability for all children, including those with unmarried, same-sex, or non-biological parents. At present, these parents are treated as legal strangers to their children. Moreover, Connecticut law is not LGBTQ+ inclusive. Same-sex couples aren't granted the marital presumption of parentage. The Connecticut Parentage Act ensures that children born through surrogacy, assisted reproduction, and LGBTQ+ couples have the security of a legal parent-child relationship. In addition to being an advocate for children and families, as a queer Muslim woman of color, this issue is also very personal to me. Queer Muslims often face a two-sided abject fear. Throughout my life, I've been a victim of Islamophobia and forced to endure the violence and vitriolic attacks against my Muslim community. As someone who identifies as queer, I've always felt like I've existed on the marginals within my own faith community due to cultural misunderstandings that have created a heteronormative binary of gender identification and sexual orientation within our traditional spaces. I've come to learn that one of the most painful experiences is to feel both denied of purpose and access to basic human rights. My intersectional identities have posed many challenges, and passing this bill would address an important one that impacts the safety and security of parent-child bonds, which are necessary for children to flourish. Thank you.
Thank you. Are there comments or questions from members of the committee? Comments or questions? If not, Ms. Shaw, thank you for joining us. I've seen you on a lot of committees, and I've seen you at a lot of committees, so I know you're doing a lot of work. I hope you enjoy the rest of your day. All right. Casey Jacob, Representative Ali Brennan, Ashley Taylor, and Stephanie Ocasio-Gonzalez. Casey Jacob.
Good morning.
Good morning.
My name is Dr. Casey Jacob. I am a medical psychologist, which means that I spend my time helping people cope with the fact that their bodies are letting them down in one way or another. And for much of my career, I was the psychologist at UConn Health and the Center for Advanced Reproductive Services. And I am speaking today urging you to vote in support of proposed Bill 6321, an act concerning the adoption and implementation of the Connecticut Parentage Act. In my work at the UConn Center for Reproductive Medicine, I specialized in caring for people who needed help conceiving. During most of this morning, while I've been listening to you, there have been roughly 60 people on this call. Almost certainly at least 20 of you have needed help conceiving. And that means that many of you have also considered adopting or conceiving with the help of a donor or a carrier. Many of you will have not ended up needing that kind of assistance, but some of you may have decided not even to become parents because of the legal uncertainties about becoming a parent through some of these pathways. And recognizing how common this is very important. In 2017, more than 10% of the babies born in Connecticut were conceived with medical assistance. That's astonishing when you stop to think about that. Choosing to accept the help of a donor or a carrier or to go down the adoption pathway is tormenting for people. And the legal issues are a big part of it. And one thing that hasn't been mentioned at all in the hearing so far this morning is the legal uncertainties if you're considering being a donor, either anonymously or for a friend or a family member, or being a carrier for somebody you care about, or even to be employed as a carrier, or choosing to place the child in adoption. Those folks also want to know that the legal parentage of these kids is written in stone, that it's really settled and that the kids are going to be cared for, that might be birthed through these technologies. So I just really want you to think about everybody. Of course, we care about the parents and the kids, but this is even bigger than that. And it's such a common issue. Keep that 10% number in mind when you think about the number of kids born in Connecticut who needed an assist or their parents needed an assist. I'm happy to take any questions, but mainly I just want to beg you to support this legislation. You have my written testimony.
Dr. Jacob, thank you very much for your testimony. Are there comments or questions from members of the committee? Are there comments or questions? I do not see any. I want to thank you for taking your time and joining us and offering your expert opinion. Have a great day.
Thank you.
Next, we have Representative Ali Brennan, followed by Ashley Taylor and Stephanie Ocasio-Gonzalez. I don't see the representative. Is Ashley Taylor in?
I'm here.
You have your 3 minutes.
Dear Chair Strafstrom and Winfield, Vice Chairs Kaser and Blumenthal, Ranking Members Kissel and Fishman, and members of the Joint Committee on Judiciary. My name is Ashley Taylor, and I am testifying in support of Raise Bill number 6321, an act concerning adoption and implementation of the Connecticut Parenting Act. I am a resident of Bridgeport and a police officer in the city. I am testifying on behalf of myself and my fiance, Adriana. Adriana and I are currently expecting a child due in mere weeks. However, it has been a journey to get here. We are extremely nervous about Adriana's legal parentaging status. Despite being my partner and co-parent in every sense of the world, Adriana will have no legal connection to our child at birth because she's not a biological parent. Adriana will have no legal connection to our child, and due to Connecticut's outdated and burdensome parentage and laws, we will have to go through the months-long process of adoption to ensure that she is legally secured as our child's parent. First, we started our journey trying to do IVF using Adriana's eggs, and this would make her biologically connected. Unfortunately, we were unsuccessful. We then resorted to IUI, and my first pregnancy ended in a miscarriage, which was very unexpected. This occurred right when the pandemic hit, which was even more stressful. When the state began to reopen, we decided to try again. We found out that we were pregnant and were told shortly after that that was not a viable pregnancy either. After feeling physically and emotionally broken, we decided to try a third time. We are currently pregnant and I am in my third trimester, but we are still full of anxiety and we're being super cautious. Since we live in a state that we think of as supportive of LGBT people, we just assume that we will both be recognized as parents under the Connecticut law. Throughout the fertility process, we have been treated by doctors and nurses as a couple who are both parents. We jointly signed contracts and forms at the clinic in which we both committed to the responsibility over any child we have. But under the law, we are not treated as parents of our children unless of any forms we sign at the fertility center. Adriana will have no legal connection to our child, and in order for her to be legally recognized as our child's parent, we would have to wait until our child is born and file adoption papers, which can cost $2,000 to $3,000. There will be a period of time when Adriana is not a legal parent to our child, which makes me scared, and that gives me a lot of fear, especially because of COVID-19. And a lot of people argue that we should just get married, and though we are engaged and plan to get married, we shouldn't have to be married in order for her to be legally recognized as our child parent. Pregnancy is incredibly stressful. I've gone through failed pregnancies in the last year, and our journey was far from easy. As a same-sex couple, it's harder for us than a heterosexual couple to have children, and it's unbelievably stressful and exhausting to go through the process. The medication, the missed work, feeling sick, and thousands of dollars with uncertainty that if we would even fall pregnant. The Connecticut Parentage Act would protect our family and guarantee that our child has the security of two legal parents from the moment of birth. The bill will allow us to sign a simple voluntary acknowledgement of parentage to guarantee that Adriana will be our baby's mother always and forever. We will be legally recognized as a family since day one. Adriana and I urge you to adopt this bill. It'll make all families equal under our law. As police officers, we put our lives on the line every day to make our communities a safer place, and all that we ask in return is that Connecticut law recognizes our family as legitimate and deserving of respect as any other family in the state.
Thank you. Comments, questions from members of the committee? Representative Curry.
Thank you, Mr. Chairman. Ashley, really great to see you again. I think it was about 2 days ago that it would have been 1 year since Representative Felipe brought you before the committee to discuss this very same bill. I'm glad to hear where you are now in your third trimester, and congratulations to you and Adriana. And just truly appreciate you really coming forward and sharing what's very personal and very sometimes uncomfortable with the members of this committee, and just highlighting again why this is so important that we get this done now. So thank you very much for coming out today.
Thank you.
Thank you, Representative. Senator Kasser.
Thank you, Mr. Chair. I feel the same way. I just wanted to say thank you for your courage in coming forward last year and this year, and also for outlining for us in very clear terms what the emotional cost is, what the financial cost is, what the personal cost is of the current statute that we have in place. And both you and Adriana are police officers. You know what it is to put your lives on the line every day, as you just said, and yet to not have the basic right to have your legal rights and parentage rights supported must be an incredible affront. So I just wanted to thank you for your courage and wish you the best of luck with your pregnancy.
Thank you.
Thank you, Senator. Are there comments or questions from other members of the committee? Comments or questions? I do not see any. I want to thank you for joining us today. I know how tough that process can be. And certainly I hope that by the time we end this session, this burden is not an additional burden on you or anyone else in the state. Thank you. Have a great day. Stephanie Ocasio-Gonzalez.
Hi.
Good morning.
Good morning.
You have 3 minutes.
Okay. Hello, my name is Stephanie Ocasio-Gonzalez, and I am testifying in support of raised bill number 6321. I'm testifying on behalf of myself and my family, my wife Denise Gonzalez, our son Javen, and our daughter Destiny. As you may recall, we sat before you and provided testimony in favor of the Connecticut Parentage Act, and here I am on behalf of my family once again. Like many others, my family and I have faced obstacles over the past year, especially due to COVID. COVID heightened an already existing fear for me, which is what would happen to our children if something were to happen to me. Having preconditions as well as working in the medical field, that question loomed over me. I gave birth to our 2-year-old daughter, Destiny, in January 2019. Both of our names are on her birth certificate, but without a formal judgment, some states may not recognize Denise as the lawful parent of our daughter. The CPA will solve this problem. We would be able to complete an acknowledgement of parentage, and Denise would be recognized as Destiny's parent in Connecticut and across the country. Our 14-year-old son, Javen, is from a previous relationship, and Denise came into our lives when he was just 3 years old. We make decisions together about his life, and we jointly provide for him. Denise is Javen's mother, and Javen feels the same. Yet because we live in Connecticut, she has no legal connection to our son. The only option to secure Javen's relationship with Denise is an adoption, which will be a difficult litigation that will require us to terminate the rights of Javen's birth father, who has no part in his life. I live in fear that if something happens to me, Javen, as well as my daughter, will lose both of their mothers. The day I received my COVID vaccine, I once again put something in writing to ensure that if something were to happen to me, Javen would remain with Denise. And if that were not respected, he should go to my mother, who I instruct to grant Denise full custody and decision-making authority. I wrote that. I do not want my children to be separated from each other or from their mother. Javen's fate should not be so uncertain. The CPA will protect Javen and the other children in his position. Under this bill, Denise could be a de facto parent by virtue of the fact that she is functionally his mother. As much as COVID brought the fears of what would happen to our children closer, it also strengthened my determination to do whatever I can to ensure that the law recognizes that Denise Gonzalez is to the mother of our children. No matter the circumstances, were Denise and I to separate next year, next week, next month, or even tomorrow, I will still be here, testifying and fighting for our rights, but especially for hers. Because no matter what the circumstances are, nothing negates the absolute fact that she is the mother of our children. We are real people, and we are here. And if life, especially with COVID, has taught us anything, it has taught us that life is short and we must live with empathy, understanding, and acceptance. Our children's lives and well-being are the most important thing to us. And I hope that you can see the importance of this bill so that no one else has to write in numerous notebooks spread throughout the house and numerous hidden letters and emails that a mother wants her children to stay with their mother if anything were to happen, the way that I have been doing for years. Thank you.
Thank you. Senator Kasser. Representative Curry.
Thank you, Mr. Chairman. Stephanie, it's really great to see you again. And really just thank you for providing again such emotional and personal testimony. I believe it was you that came forward last year, and after you spoke, Senator Kissel was so overwhelmed that at that very moment, I believe, is when he put in his name for co-sponsorship of this legislation. Because I think our colleagues know we can have a number of professionals come before us to talk about the importance of this, but until you give it that personal lens and it's actually real to someone personally, I don't think people actually fully understand how impactful a piece of legislation can be. Because no one should have to have scattered notebooks around their house or worry that they're going to get a COVID shot and what may happen to their children and their other mother. But that's absolutely ridiculous. So again, just truly appreciate you coming forward and sharing your emotional story. Thank you very much. And thank you, Mr. Chair.
Thank you.
Thank you, Representative. Comments or questions from other members of the committee? Comments or questions? I do not see any. Thank you, Ms. Ocasio-Gonzalez, for joining us today. And I would just align myself with Representative Curry's comments. I hope you have a great day.
You too. Thank you.
We'll next hear from Mark Randall, followed by Melina Simard-Halm, and then Catherine Crashall. Is Mark Randall in and ready to go? You have 3 minutes.
Hello, Senator Winfield, honorable senators and representatives of the Judiciary Committee. My name is Mark Randall, and I am before all of you today on behalf of the Connecticut Bar Association Family Law Section, and specifically in my role as a member of the Executive Committee to express the Family Law Section's full support for House Bill 6321, an act concerning the adoption and implementation of the Connecticut Parentage Act. As a starters, I also want to thank Officer Gonzalez and Ms. Ocasio-Gonzalez for telling their stories and their concerns for their children's rights and their partners' rights are the exact reason why the Connecticut Family Law Section supports this bill. Now, just a little bit about myself. I'm an attorney with Needle Kuda, a law firm in Westport, Connecticut, which practices exclusively in the area of family law. And I myself have been a family law attorney since graduating from the University of Connecticut School of Law. Now, the CBA Family Law Section is in full support of the Connecticut Parentage Act. It's an incredibly important piece of legislation that will update the current family law statutes, as well as the family law jurisprudence here in Connecticut. The current family law statutes are antiquated in their views of parentage, basing parentage solely upon marital status or a heterosexual relationship. Now, this does not provide the adequate legal protections and rights that all families in Connecticut should be afforded. And the Connecticut Parentage Act seeks to right this wrong and update the Connecticut family law jurisprudence to provide equal access to a parent and child relationship for all individuals, regardless of marital status, gender, or sexual orientation. The Connecticut Parentage Act also provides protections for current legal parents or genetic parents from what I will term as a spiteful ex-partner, somebody that might be attempting to now utilize the Connecticut Parentage Act when it becomes law, merely to exert control over or emotional harm to a parent and in turn the child without any real desire to be a legal parent, only to exert that control. And it's with these protections in place, which are in existence in the currently drafted Connecticut Parentage Act, that the Family Law Section has provided written testimony through myself outlining our certain proposed amendments to presume parentage and de facto parentage, not only to bolster the current protections in place, but also put an importance on the relationship between the child and the individual who is seeking to be adjudicated a legal parent. Now, a very important note, these proposed amendments do not limit the Family Law Section's support of the Act. Now, I want to thank the committee for raising this very important bill. And of course, I want to extend a personal thank you to Professor Doug Najam, who had to put up with many emails from myself, lengthy telephone calls, and of course, the incredible yeoman's work of collaborating with all of the interested parties to get the act before the legislature, truly representative of Connecticut. And the Connecticut Family Law Section looks forward to a continued relationship with the Judiciary Committee, as well as with the legislature itself as this bill moves forward and finally gets in front of the governor. And with that in mind, I welcome any questions that anybody may have.
Thank you, Attorney Randall. Are there comments or questions from members of the committee? Comments or questions? I do not see any, but thank you very much for joining us today and offering your testimony.
Thank you.
Have a great day.
You too.
Next, we'll hear from Melina Simard-Halm.
Thank you, chairs and members. Can you hear me?
We can't hear you. You have your 3 minutes.
Great. Thank you, chairs and members of the Judiciary Committee for allowing me to testify today in support of the Connecticut Parentage Act. My name is Melina Simard-Halm, and I'm a 5-year resident of New Haven and a member of Collage, an organization dedicated to advocacy for children of LGBTQ parents. I'm able to speak to you today because 25 years ago, my dads persevered in the face of laws that saw them as unfit to be parents. For 10 years, they braved shut doors, slurs, and a hostile legal system because they knew their dearest wish in life was to love and care for a child. Just when they were going to give up, surrogacy came through and I was born. At the time of my birth, I was one of the first children born through assisted reproduction to 2 gay men. When I was born, I was not legally the child of one of my fathers. My parents went through a grueling legal process to secure parentage rights. During that time, one of my fathers was deprived of all rights to custody and decision-making authority. Even though I was not legally the child of one of my fathers, even though many treated us with disgust and disdain, I'm certain that my life from the moment I was born has brought my father's deep and abiding joy. And because of my dad, I have grown up in a family that has shown me the meaning of love, that supported me so much that now I'm lucky enough to be here advocating so that people don't have to go through what they did. Today, I hope that I can show you that people like my parents deserve to be treated as parents in every sense, and that families like mine should not be excluded from the protections of the law. A quarter century later, Connecticut still does not provide LGBTQ couples equal access to securing parentage. Many children like me must experience the legal uncertainty that my family did. Many must still confront the fear that they could be separated from their parents in the case of conflict or tragedy, and that they must live with the possibility that in case of an emergency, their parent could not be there to make decisions for them. Exclusive parentage law sends a message that children like me do not belong. When I was growing up, law like Connecticut's gave authority to the schoolyard bullying and kindled my own insecurities. At times, it led me to feel ashamed of the people that loved me and fought for me the most. Mr. Chairman, the families who this law protects are not asking for special treatment. My parents certainly weren't asking for that. They're asking to be allowed to participate as equals in perhaps the oldest and happiest activity, to care for and love their own children. Thank you so much for your time.
Thank you for your testimony. Senator Kasser.
Thank you so much, Mr. Chairman. And thank you, Melaine, for describing the children's perspective in all this. And I can't imagine how difficult it must have been for you. You just described that you felt bullied and ashamed and insecure in the situation. How old were you when you became aware of what the legal situation was? How was it conveyed to you? How did you experience this? I'm sure your dads reassured you in every way they could, but how did this impact you growing up?
Thank you for your question, Senator Kasser. I think that children like me often have to grow up knowing that there are laws and the public is still deciding about what it means to have a family like mine. And that was very difficult for me growing up. Even though I experienced an extraordinary abundance of love from my family, I also grew up knowing that people did not believe that my dads were fit to have a family. And sometimes it made me feel like I needed to lie about who my parents were. It made me feel like I needed to push them back in the closet. And I felt I betrayed the people that loved for me and fought for me the most. It's law like this that sends a message to children, families like mine, that we're just not meant to be in the same way, that we do not belong. And I hope that this year, Connecticut adopts this law so that children like me don't have to experience not only the material disadvantages of not being protected by the law, but the stigma of knowing that our parents aren't recognized the same way.
Thank you so much. And thanks for your courage. Thanks, Mr. Chairman.
Thank you, Senator. Are there comments or questions from other members of the committee? Representative Howard.
Thank you, Mr. Chairman. I'll be brief. Melina, I just want to thank you for being here today. I think that your testimony, your poise, your courage certainly demonstrates just how well two men raising a child can do. I hope my colleagues heard you loud and clear. I hope they got that example loud and clear. And as a person I said earlier who works diligently to ensure that children have great environments to grow up in, I know personally that there are a lot of kids that I deal with that grow up in environments where their parents are of the same gender and they have just absolutely wonderful upbringing. So I hope that my colleagues here today can take that example from you. So I just wanted to make that comment to you and say thank you. Thank you, Mr. Chairman.
Thank you, Representative. Are there comments or questions from other members of the committee? Comments or questions? I don't see any. Ms. Simmerholm, thank you very much. And I would just say to the last exchange, at the very least, I heard you loud and clear. I hope we get this done this year for you and for all of the people of the state of Connecticut. Thank you very much. Hope you enjoy your day. Catherine Crashall followed by Eric Russell. Catherine Crashall, Eric Russell. Good, still morning. Attorney Russell, you have 3 minutes.
Good morning to Chairs Winfield and Staffstrom, Vice Chairs Kasser and Blumenthal, Ranking Members Kissel and Fishbein, and members of the Joint Committee on Judiciary. My name is Eric Russell, and I'm an attorney at Pullman and Conley. I'm also the past chair of the LGBT section of the Connecticut Bar Association, and I'm here today in this professional capacity to provide testimony in support of Raise Bill 6321, an act related to the Connecticut Parentage Act. The LGBT section has supported the Connecticut Parentage Act since its inception. As a group, we firmly believe in the importance of protecting all of Connecticut's families, regardless of the circumstances of a child's birth or the marital status, gender, or sexual orientation of their parents. One of the section's stated purposes is to promote the participation of the Connecticut Bar Association in substantive areas of law and legislation that present issues of particular concern to LGBT individuals in the profession and those who seek legal services. The Connecticut Parentage Act is just such an act, such a piece of legislation. The Connecticut Parentage Act will provide necessary protection to all of the state's LGBT families by filling gaps in existing law and ensuring pathways to protection for the children of unmarried, same-sex, or non-biological parents. For decades, Connecticut has been a leader on LGBT issues. We were the second state in the nation to recognize marriage equality, and the legislature has long been a valued partner in securing the equal status of the state, equal status of LGBTQ families in Connecticut. Yet Connecticut is now the only New England state without comprehensive protections for non-biological parent-child relationships, which LGBT families ordinarily feature. The Connecticut Parentage Act would modernize our state's outdated and unconstitutional parentage laws to provide equal protection and treatment for LGBT parents and their children. The LGBT section of the Connecticut Bar Association has officially endorsed this piece of legislation and considers it a high priority. And I'm here today to urge the committee to support the bill. I thank you for your time and happy to take any questions.
Thank you, Attorney Russell. Are there comments or questions from members of the committee? Comments or questions? I do not, I do not see any. That being the case, Attorney Russell, it's good to see you again, and thank you for coming to testify. Enjoy your day.
Thank you, Senator.
All right, we will next hear from Patience Crozier, followed by Andrew Power and Michael Rinaldi. Is Patience Crozier ready to go? You have 3 minutes.
I'm here. Thank you so much, chairs and members of the Joint Committee on Judiciary. Thank you so much for the opportunity to testify in support of Raise Bill 6321, the Connecticut Parentage Act. And thank you particularly to Representative Curry and all of the co-sponsors. So my name is Patience Crozier. I'm an attorney at GLBTQ Legal Advocates and Defenders, where I focus my work on youth and family issues. And before I worked at GLAAD, I was a practicing family lawyer, and I litigated a number of cases involving parentage. And I'm also a non-biological parent of children conceived through assisted reproduction, and I had to adopt my own children. I've had the pleasure of working in coalition on parentage reform efforts throughout New England. And to me, there's nothing more foundational for a child than the security of her legal parent-child relationship. And in my practice, both at GLAAD and prior to that, working with LGBTQ families, I have unfortunately seen firsthand the tragedy of outdated laws and holes in protections. I have represented a loving, non-legal parent whose child was kidnapped out of state and separated from her for 2 years. I've accompanied a non-biological parent on a race to court to keep her child from entering foster care because the legal parent had a dire medical emergency. And I have fought alongside a non-biological parent who was not recognized by a parent as by foster care officials. I helped her get counsel, to get included in the child welfare proceedings, and to establish her legal parentage so she could get custody back of her child. As you will hear today and have heard already from directly impacted Connecticut families, the status quo leaves children truly vulnerable. And this is particularly true for children of LGBTQ parents. These families are often formed through assisted reproduction. They're often parents through intent and conduct as opposed to genetics. And Connecticut is the only New England state without protections for non-biological and non-marital parents. The assisted reproduction statutes only protect marital children. There's no non-marital presumption, there's no de facto parentage, and these protections exist in every other New England state. These holes mean that children are unable to be protected in their most precious relationships. And in a state like Connecticut, which is the second highest rate percentage of births through assisted reproduction in the country, a really robust LGBTQ population, and a history of leadership on LGBTQ family issues, I think this is an incredibly important bill to ensure the security of children, improve access to justice, and clarity in the courts. I just want to thank everyone who's worked so hard on this bill to date. It truly has been a collaborative process of deep and thoughtful engagement by so many. And I'm really hopeful that this will be the year that Connecticut parentage laws protect all children. GLAD enthusiastically supports this bill and hopes it will be reported out favorably. Thank you so much.
Thank you, Attorney Crozier. Representative Curry.
Attorney Crozier, a pleasure to see you as always. Just want to thank you for all the tremendous work that you are doing here in Connecticut, but also throughout New England on behalf of GLAD. And my question is, I was hoping that you could kind of expand upon differences between Connecticut and some of our other New England states, and maybe some of the conversations and dialogue that the other legislatures had, and bipartisan support, and kind of touch on all of those things.
Absolutely. Thank you so much. It's a great question. I have to say it has been one of my privileges at GLAD to work on reform efforts of this kind, because they have been so collaborative in all states and really child-centered and bipartisan bills. I mean, I'm currently working on this bill in Massachusetts, and our lead sponsor in the Senate is a Republican. And really, people see the value of, for all families, not just LGBTQ families, children have to be protected to their parents from the moment of birth. And we have really seen like resounding support. We passed this bill. I think it was one of the only bills passed in Rhode Island last session, despite COVID and the really terrible impacts of COVID and on the legislative session, because people saw the vulnerabilities that were happening for children in Rhode Island in any event. So I think that I've had the pleasure of working in Vermont, in Rhode Island, in New Hampshire, and now in Connecticut and Massachusetts. And I think it's, just a really kind of, like the Attorney General said, a common sense, basic housekeeping that needs to be done for children.
Thank you for that. And I'd like to believe that, yes, this will be the year that we get it done. And I think had COVID not shut us down last year, we would have gotten it done, but I'm almost glad that that didn't happen, because of the amount of work that has happened between a year ago and today to get the bill to where it is now. And that couldn't have happened without your support and the countless calls and meetings that you and Professor Needham and all the proponents have had over the last year. So again, thank you very much for everything that you're bringing to the table on this issue. Thank you, Mr. Chairman.
Thank you, Representative. Are there comments or questions from other members of the committee? Comments or questions? I do not see any. Attorney Crozier, thank you very much for joining us and offering us your testimony. I hope you have a great day. We next have Andrew Power, followed by Michael Rinaldi and John Board. Mr. Power.
Yes, thank you, Senator Winfield, and all the members of the Judiciary Committee. If it's okay with you, I'd like to testify in conjunction with Mike Rinaldi. We spoke earlier, and I feel that we can kill two birds with one stone, if that's okay with the committee members.
He is signed up. That's fine with me.
Are you on, Mike? Yep.
Yes, I am.
So committee members, my name is Captain Andrew Power. I'm with the Windsor Police Department. I've been with the Windsor Police Department about a year and a half. And prior to that, I served 28 years with the Wethersfield Police Department, retiring there as a lieutenant. I'm representing the Connecticut Police Chiefs Association today, and to speak of House Bill 6564, which is an act concerning secondhand dealers, precious metals, or stone dealers and pawnbrokers. The Connecticut Police Chiefs Association does not support this bill, and that's about all I have to say at this point. I'd be willing to take some questions if people have any questions about it, or if Mike, do you want to say more about this?
There's a couple things I want to say on this. My name is Michael Rinaldi. I have over 40 years involvement in law enforcement, 27 years with Monroe Police Department, and 16 years with the New England State Police Information Network. And I'm also president of the Connecticut Narcotics Enforcement Officers Association. And in both cases, I'm opposing Bill 6564 for a couple of reasons. One being that it's still shown a huge nexus between the opioid problem, property crime, organized retail crime, and the pawn shops. Making it easier by being able to pay out cash, I think, is only going to encourage this type of behavior and create more of a problem with stolen property. There is a huge nexus between all of this being tied in together. And also, as a senior law enforcement coordinator with NESPN, one of the things we do there is we have a database, RISPROC, the Property Recovery and Tracking System, which now has over 22 million records in it, is contributed into by over 13 states, and it has helped solve more property crimes, primarily with, dealing with pawn shops. But one of the biggest statistics coming out of that has aided in the recovery of approximately $8.2 million worth of property for victims. Now, information comes to us in many cases directly from the pawn shops, in some cases from the police departments in which those shops reside. And I've seen this covered not just property crimes, not just burglary, robbery, and larceny cases. This has also helped out and tied in a few homicide cases. So you can see the extent of it. And one of the big things I can see, utilizing our database, is that going to pawn shops is not a local type of a situation. Those who, and don't get me wrong, the vast majority of people that go to pawn shops and the vast majority of transactions are 100% legitimate. But for those that wish to do something illegal, to try to gain, cash or whatever, it's just giving them greater opportunities. We see so much going out of state, so much going out of region, someone stealing something or living in one part of the state and going to a pawn shop an hour and a half away in the hopes that it's not going to be found out or they're not going to be caught. But it's amazing how much stuff goes across state lines on a very regular basis. So that is why, I, as president of the NEOA and as the senior law enforcement coordinator at NESPN, I'm opposed to this bill because I think it's going to create more crime and make it much more difficult for law enforcement. Right now, what we have in place is really aiding law enforcement in solving crimes. I'm happy to take any questions.
Thank you both. Are there comments or questions from members of the committee? Comments or questions? I do not see any, but we will certainly take your testimony into account as we continue with the bill or do not. Is your testimony written? Do you have written testimony?
No, I did not. I was just informed of this a day ago.
And Mr. Power, did you?
I did not submit anything written, no.
If you think about it, just as part of what we do going forward, it might be useful if you supplied some written testimony to the committee as well.
Okay.
Very good, sir.
Thank you for joining us today.
Thank you.
Hope you both have a great day.
Thank you.
Thank you.
John Board.
Hey, Senator, how are you?
I'm doing well. You have 3 minutes.
Thank you. Good morning, or good afternoon, Chairman Winfield, Chair Sastrom, Ranking Member Kissel, and Fishbein, members of the Judiciary Committee. Thank you for the opportunity to testify on 6321. As the Senator said, my name is John Board. I'm currently the chair of New Britain Pride, the city's LGBT nonpartisan outreach organization. Connecticut has been a leader in the LGBTQ arena for decades, and our state has been on the forefront of several major steps forward for our community, most notably being the second state to recognize marriage equality. Once again, today you have the opportunity to help secure LGBTQ rights for families. Connecticut is the only New England state without protections for unmarried and non-biological parents and children. With the passage of the Connecticut Parentage Act, we'll finally ensure equal access for legal parentage for every child in this state, no matter whether these parents are unmarried, of the same sex, or non-biological. Personally, as some of you know, I'm adopted, so this is as a non-biological child is a very personal issue for me, as well as a member of the LGBT community. I wanted to give a specific shout out to Representative Curry, Senator Casa, and Representative Claire, as well as all the other co-sponsors of this bill. I urge the committee to vote yes on this piece of legislation, and I'm prepared to answer any questions the committee may have. And once again, I apologize for all the technological issues. Been on a few different Zooms this morning, so sorry for being on my phone. Thanks so much. Have a good day, and thank you, Mr. Chairman.
Thank you, Mr. Board. Are there comments or questions from members of the committee? Comments or questions? I don't see any, but thank you for joining us this morning and offering your testimony, and you were pretty smooth, so don't worry about it. Have a great day.
Hey, thanks so much, Sunday. Have a good one.
You too. Next is Representative Kavros DeGraw, followed by Hugh Taylor, Andrew Gearing, and Matt Capecci. Representative, you have 3 minutes.
Yes, good afternoon, Chairman Winfield and Staffstrom, Vice Chairs Kasser and Blumenthal, Ranking Members Kissel and Fishbein, and members of the committee. I come before you today to testify in support of proposed bill number 6321, the Connecticut Parentage Act, which I have co-sponsored, and it will update the state's parentage law to promote the security of all children. This legislation is critical because Connecticut law currently does not protect LGBTQ couples raising children and leaves the relationship between the non-biological parent and child vulnerable. I'd like to share with you a bit of the testimony from my constituent, Dana Barcelos Allen, as she did submit it but was unable to speak live today. Dana and her wife, Carrie, welcomed a beautiful baby boy, Cooper, 2 years ago. As she recalls, my wife and I are legally married. We married in California prior to moving to Connecticut, and we would have been recognized under Connecticut state law, but federal recognition had already happened by that time. We moved here in 2016. Having that marriage recognition might seem to many sufficient enough for my parental rights to Cooper as the legal spouse of his biological parent. However, federal or state recognition of my marriage is not guaranteed. It is subject to legislative and judicial actions which are influenced by political opinions and administrations. Dana goes on to share, Cooper doesn't know that my wife is his biological mother and that I have no actual biological connection to him. He doesn't know that I painstakingly went through hundreds of profiles searching for a donor for him. Cooper doesn't know that I gave my wife hundreds of hormone shots during our 2-year infertility journey, where we underwent hope and heartbreak through 5 failed intrauterine insemination attempts and 1 failed in vitro fertilization attempt, until at last, our baby became a perfect reality. He doesn't know that I saw him first or that I cut his umbilical cord. He does know unequivocally that he's loved by 2 parents. He calls us both mama, and he's happiest falling asleep when both of us are within his touching distance. When he wakes from a nightmare, biology isn't on his mind. When he falls, he's not thinking of biology. He simply wants his parents. He knows that our unit, the parents that love him, make up his family. And that's what this bill is about, right? Not just for LGBTQ couples, but for any and all families. Connecticut law doesn't protect children's relationships with unmarried, non-biological parents and treats those parents as legal strangers. In fact, we're the only state in New England that does this. I think about the time before my own mother was able to remarry to my wonderful stepfather, who was fully participating as a parent in my life, but would have had no rights, say, in an emergency room, if my mom, who was an international flight attendant, was unavailable to make medical decisions for me. As another of my constituents, Dr. Alex Hogan, a local physician specializing in pediatric hospital medicine, said in his submitted testimony, a child who is sick without a parent at the bedside due to an unjust law is exactly what the CPA will prevent. As a physician specializing in pediatric hospital medicine, I've seen delays in care as a direct result of a lack of clarity around medical decision capacity, and this law will help prevent those harms. The bottom line is what makes a family is love. The Connecticut Parentage Act ensures all children have the equal access to a legal parent-child relationship, regardless of the circumstances of their birth or the marital status, gender, or sexual orientation of their parents. This law will protect all Connecticut's children. Thank you for your time.
Thank you, Representative. Representative Curry.
Thank you, Mr. Chairman. Good afternoon, Representative. Great to see you. Just want to say thank you. Please also thank Dana for her testimony. I'm sorry we weren't able to see her live today. And also thank you for being one of our original co-introducers, as I know this is not only personal for you, but for a number of your constituents. So thank you very much for coming out today.
And I would just add one more thing. I think about my children and I think about everyone's children, and the fact that we could put this in place so that there never has to be a question moving forward is the most critical thing about this law. So I really hope that this is the year that it moves through and we're able to make this happen for so many families.
Thank you. Thank you, Representative Curry. Are there comments or questions from other members of the committee? Comments or questions? I do not see any, Representative. That being the case, thank you very much for joining us, and I hope you enjoy the rest of your day.
You too.
Next, we'll hear from Hugh Taylor. Mr. Taylor.
Great, thank you. Appreciate being here today. My name is Hugh Taylor, and I am the chair of the Department of Obstetrics and Gynecology at the Yale School of Medicine and chief of Obstetrics and Gynecology at the Yale New Haven Hospital. I'm also president this year of the American Society for Reproductive Medicine, the professional group that represents physicians practicing in the field of fertility and infertility. I'm also a practicing infertility doctor. I work in the Yale Medicine Fertility Center, and I'm representing Yale Medicine Fertility Center and the Yale Medicine Greenwich Fertility Practice. And in our practice, we're all about building families, and we support the Connecticut Parentage Act. Connecticut laws do not currently reflect modern practice, the way we build families today. We have all sorts of new technologies such as egg donation, sperm donation, surrogacy. There are lots of ways that one can become a parent and start a family, regardless of gender, marital status, sexual orientation, or medical conditions that don't allow one to become a parent in the traditional fashion. A child's relationship to their parents is really critical to their well-being, and we want to promote security for all children and all families. The reality is that modern families are created in multiple ways that all should be recognized. We need parents and children to have equal access to the legal protection and the security that it provides. Thank you.
Thank you. Are there comments or questions from members of the committee? Comment or questions? I do not see any, but I want to thank you, Mr. Taylor, for joining us today and offering your testimony. Hope you have a great day.
Thank you.
Next, we'll hear from Andrew Gearing, followed by Matt Capecci, Kenneth Krajewski, Kate LeBlanc. Mr. Capecci, are you in?
Yes, I'm in.
You may begin.
Okay. All right. Thank you, co-chairs Winfield, Sastrom, ranking members Kissel, Fishbein, and members of the committee. My name is Matthew Capice, and I'm testifying in support of Senate Bill 363, expanding the duties of the Office of the Attorney General. I have also submitted written testimony. I serve as a representative of the General President of the United Brotherhood of Carpenters and Joiners of America. My duties focus on the nationwide problem of rampant wage theft and fraud in our industry that victimizes workers, insurance companies, taxpayers, and law-abiding employers who cannot compete against the scofflaws. I began this work in 1989 in Connecticut, where I am still a resident. There is growing lawlessness in the United States involving scofflaw construction employers failing to pay wages, state and federal employment taxes, unemployment insurance, and workers' compensation premiums. They also cut corners on safety, which is especially troubling in the midst of the COVID-19 pandemic. And Connecticut is not immune to these problems. A national study of fraud in our industry released in 2020 found that 1.3 to 2.2 million construction workers were paid off the books or mischaracterized as independent contractors in 2017. That is astounding. 12.4 to 20.5% of the construction workforce is treated improperly. Illegal practices resulted in an $8.4 billion loss to federal and state taxpayers. Workers' compensation carriers lost $2 billion, and construction workers had lost almost $1 billion in overtime and premium pay that was stolen from them. The violations we have been seeing are not isolated to small jobs. We have seen them occur on military bases, schools, universities, large retail stores, office buildings, condominium towers, and even on an Internal Revenue Service office building. Many of these job sites are managed by some of the largest general contractors and construction managers in the industry, including contractors that operate regularly here in Connecticut. Moreover, the abuse we see in the construction industry reflects systematic racism and bigotry. The vast majority of the exploited are immigrants and people of color. This is shameful. Workers' rights are indeed civil rights and need to be recognized as such as they are in this bill. Connecticut has fallen behind. Other state legislatures have recognized the benefits of attorneys general protecting law-abiding employers and their employees. Those include Florida, New Jersey, New York, Massachusetts, Illinois, Montana, Minnesota, Tennessee, California, Washington, Oregon, Virginia, Louisiana, Nevada, Iowa, Michigan, Vermont, and Missouri, as well as the District of Columbia. The members of the United Brotherhood of Carpenters
Mr.
share the
Khalif,
same beliefs.
your time has elapsed. If you could summarize.
Well, we respectfully request that you give the Office of the Attorney General the tools to protect workers, employers, and the taxpayers of Connecticut, as a bipartisan array of other states have done. Thank you very much.
Thank you, and I apologize for messing up your name initially. Are there comments or questions from other members of the committee? Comment or questions? I do not see any, but thank you again for coming and testifying before us today. I hope you enjoy the rest of your day. Next is Ken Krajewski.
Good afternoon, members of the Judiciary Committee. I want to thank you all for allowing me to testify today. And I'm testifying in opposition to Senate Bill 363. I'm deeply concerned about the lack of a firewall in the bill. The Office of the Attorney General represents civil rights violators who work for the state of Connecticut, and I find an incongruity between the Office of the Attorney General representing agencies of the state of Connecticut and zealously defending their ability to violate civil rights, while at the same time saying the Office of the Attorney General can prosecute private parties or municipalities for civil rights violations. I'll give you an example. I'm litigating the fallout from the Attorney General's decisions to litigate a case right now. It's called Tangredi versus Bachman, and Kara Tangredi was in York Correctional Institution for several years on a nonviolent offense, and she was raped repeatedly by 3 correctional officers. The COs were prosecuted and jailed, so she went after the supervisors because it seems to speak normal, or to speak that if 3 COs were raping someone, there had to be a pattern or practice, or there had to be some sort of supervisory negligence or liability. And she survived summary judgment against one of the supervisors, and the Office of the Attorney General Public Safety Division actually went and appealed that to the Second Circuit Court of Appeals of the United States court system, and they overturned the decision. And so now supervisory liability in the Second Circuit is in disarray, and it's very difficult now for civil rights plaintiffs to hold supervisors liable for things like their underlings who rape people repeatedly. If, as Attorney General Tong testified today, that this bill is designed to help women, I'm not seeing it. because as some of you may know, and we have bills that will be before the Judiciary Committee, and we have been before the Judiciary Committee repeatedly about prisoners' rights, and Attorney General Tong talked about class actions. Attorney General Tong's office, through the Department of Public Safety, fought the hepatitis C class action that I litigated and won class certification on, and they fought it tooth and nail. So I'm wondering how the law firm for the state, which is charged with protecting the state and giving zealous advocacy to agencies and protects people who violate civil rights, can turn around and then say, we're going to go after civil rights violators in other parts of the state. So I need to see a firewall, or I need to see the Public Safety Division dissolved and the job of defending civil rights violators in the state police, in the Department of Correction, in the Department of Children and Families, farmed out to private law firms.
Attorney Kraske, your time's elapsed. If you could summarize.
I would just say that I agree with the concept that we should probably be in step with other states across the country that provide certain powers to the Office of the Attorney General to pursue civil rights violators. But at the same time, I feel like we need to make it clear that there is an inconsistency in the idea that the Office of the Attorney General defends heinous actions taken by state employees, yet will claim the mantle of saying, I'm going to go after other people for the same thing. Thank you very much.
Thank you. Comments, question from members of the committee? Comment or questions? Attorney Kraske, do you submit written testimony?
I can, if you would like, Senator Wilson.
Yes, please. If you can do that, that would be helpful.
I will do so. Thank you.
Thank you. A comment or question from members of the committee? I do not see any. Thank you for joining us again, Attorney Kraske. I'm sure we will see you soon.
Yes, thank you so much.
Okay. Next, we'll hear from Kate LeBlanc.
Hello, good afternoon, everyone. Thank you, Chairman Winfield, and all the members of the committee. Thank you for having me. I have submitted my written testimony, so I will be very brief out of consideration of your time and efforts on this and many other hearings. So I am Kate Weldon LeBlanc. I'm very proudly the Executive Director of Resolve New England. Resolve New England is a nonprofit organization that provides emotional support, unbiased education, and advocacy for anyone in New England that is struggling with fertility and family building. And Resolve New England and myself personally are very proud to support the Bill 6321, the Connecticut Parentage Act. And I, again, will be brief because, of course, an organization like ours, our priority is people who need different paths to parenthood to make their dream of family a reality. And I could never speak more powerfully than the families you've heard from already today, but they are perfect examples of the main message that I want to send to you today that maybe is not even in my written testimony, which is just that, as you've seen, these families, these couples work with extraordinary intention to be parents. Regardless of the makeup of their family, they go through, frankly, more than most people to become parents. Fertility treatment and other paths to parenthood are often physically grueling. They are almost always emotionally grueling. Often they're extremely financially challenging. These people have literally worked so hard to become parents, and in many cases are still working to grow their families. The least we can do in Connecticut and in other states is to make them not have to struggle to secure their legal rights of parentage when that family is built. So I really want to thank Representative Curry, especially, I hope he can hear me, for his steadfast leadership, as well as my fellow coalition members, and also just all the co-sponsors for their support of this important legislation. I feel so confident that this is the session. Look at I'm seeing one of the beautiful families right there. I feel like this is the year, and we're so grateful to this committee for always being so respectful of our coalition. Thank you.
Thank you, Ms. LeBlanc. Are there comments or questions from members of the committee and Representative Curry?
Good afternoon. Thanks so much, Kate, for coming out. Sorry, I was just jumping between the conferences and everything, but I was listening.
No problem. I wanted you to hear thank you for sure.
Thank you so much, and I appreciate you just truly being a part of this coalition, probably one of the largest coalitions that I think I've seen come together around any bill over the last 6 years that I've been. So thank you very much for your advocacy.
Thank you, Representative. Are there comments or questions from other members of the committee? If not, thank you for joining us today and offering your testimony. Have a great day.
Thank you.
Next will be Emily Pagano.
Hello. Thank you to Chairs Winfield and Staffstrom and members of the Joint Committee on Judiciary for the opportunity to testify in support of Raised Bill number 6321, an act concerning the adoption and implementation of the Connecticut Parentage Act. I'm Rachel Prehudka-Spindel.
And I'm Emily Pagano. And this is Dylan. He's a little cranky at the moment, but glad to be here.
Today, we like to share with you a little about our family, whose legal status would be directly impacted by the Connecticut Parentage Act. Emily and I have been together for over 10 years now, and in the fall of 2017, decided to grow our family and become parents together. By the following January, we had established care with the UConn Center for Advanced Reproductive Services and developed a plan to conceive. In February, I had a successful egg retrieval, and the next month we transferred one embryo to Emily.
Soon after I found out I was pregnant. Throughout the entire process of conception and pregnancy, Rachel and I attended every appointment, class, and consultation together. Together, we shared the joy of each pregnancy milestone. Our family threw us a beautiful celebration, surrounding us in love as we entered parenthood. After much anticipation, Dylan was born, and we welcomed her into our family. We continue to co-parent Dylan in every way possible.
Throughout everything, we were beyond lucky to be surrounded by supportive family, doctors, midwives, nurses, and community. However, the issue of my legal parental status was always lying under the surface. While Emily was still pregnant with Dylan, I called the Connecticut Vital Records office to find out how I could establish legal parentage. I was informed that because I was not a man and therefore not a father, that there was no way to establish my parental rights. Similarly, while Emily and I were in the hospital enjoying our first days as parents, the birth registrar came to our room strongly asserting that I was not a parent according to Connecticut and would not be recorded as such. To this day, I have no legal standing as Dylan's parent. Additionally, this reality has brought particular anxiety for us this year given the COVID-19 pandemic. Thankfully, we've all remained healthy, but had something happen to Emily, nothing exists to protect my parental rights to Dylan, and had Dylan become sick, I would have not had any parental right to make a medical decision for her. And while this may have been on the forefront of our minds this year, pandemic or not, without the Connecticut Parentage Act, we will always face these risks.
Today, we are preparing to add 2 additional children to our family, as Rachel's due in June with twins we conceived using an embryo created from my eggs. As was the case for Rachel with Dylan, I will not be recognized under Connecticut state law as a parent of our 2 new children when they're born. And one immediate impact of this, just one of many, is that I won't be permitted to add our newborn children to my health insurance plan, which will cost our family thousands of additional dollars coming in. This is just one of the many challenges our family will continue to face without the passage of this bill. For these reasons, we voice our strong support of Raised Bill 6321, an act concerning the adoption and implementation of the Connecticut Parentage Act. For us, this bill provides legal legitimacy to our family, a right afforded to any heterosexual couple in our situation. And just as importantly, this bill brings Connecticut law up to date and shows that today's families in all of their forms are recognized and welcome in Connecticut. Finally, we'd like to express our appreciation to all of the folks who've worked so hard to make this bill a reality, and to all of you for allowing us to share our testimony today.
Thank you very much for offering your testimony, and the way you guys pass back and forth and maneuver. Clearly, you're both parents. Representative Curry.
Thank you, Mr. Chairman. It's great to see the 2 of you again. And I gotta say, Dylan has gotten quite big. I was going through my phone the other day, and actually this picture of the 4 of us is one of the last ones I have pre-COVID and pre-masks, and when we could actually all stand next to each other and touch one another. So it's really great to see you. And thank you again for coming out and really sharing your story. And again, putting that personal lens on it is what's going to make this cross the finish line this year. So thank you for adding your voices to this very important effort. Thank you, Mr. Chairman.
Thank you, Representative. Are there comments or questions from members of the committee? Senator Kasser.
I'll just add one comment. Hopefully, by the time you give birth in June, this will be passed, this will be law, and you'll have a new legally established parentage to look forward to. So thank you so much for sharing your story, and good luck with the pregnancy also.
Thank you, Senator Kasser. Comment or question from other members of the committee? Comment or question? Seeing none, I want to thank you very much for joining us today and testifying and making this giving us a real example of what this really means. Have a great day. Sarah Sampoli, Jay Sargent, Mike Martorelli. Sarah Sampoli, are you here?
Yes.
You have 3 minutes.
Thank you, Mr. Chairman and members of the committee. My name is Sarah Sampoli, and I'm a student at Yale Law School and a resident of New Haven, Connecticut. Along with my colleague, Callie Higgins, who will speak later, I speak on behalf of over 40 fellow law students who have worked on House Bill 6321, the Connecticut Parentage Act, for the past 2.5 years. As law students in Connecticut, we urge you to support this bill. Some of us are personally impacted by the bill's provisions. Some of us have had relevant professional experiences, and all of us are committed to the bill's provisions, strengthening equality for women and LGBTQ people. For those of us who grew up in the state, such as myself, that commitment runs even deeper. Apart from a brief period between college and law school, I have lived in Connecticut my whole life, for 24 of my 28 years. I was born at Yale New Haven Hospital, graduated from Amity High School in 2010, and attended Yale for college and law school. I'm proud to call Connecticut home. I've always known Connecticut as a state that recognizes the importance of supporting all of its families, a value that has undoubtedly shaped my own views on justice and equality. Just the other day, I found stuffed in a box of old papers at my mom's house an essay I wrote as a 6th grader in 2004 about the importance of securing marriage equality for same-sex couples. I remember feeling so proud in the years that followed as I watched Connecticut become a national leader in affirming the rights of its LGBTQ citizens, first by recognizing civil unions in 2005, and then by legalizing same-sex marriage in 2008. We were just the 3rd state in the country to do so. There's no doubt that Connecticut has had an impressive legacy when it comes to protecting its families, and we must take this opportunity today to build on that legacy. Because right now, our laws are lagging behind. Under the laws currently on the books, families with non-biological, non-marital children are not provided the same legal protections as those with biological children born to married parents. Indeed, Connecticut is the only New England state, as so many of the other speakers have testified to, that does not extend legal parentage to these families. The CPA is a common sense measure, or as the AG put, a no-brainer, to ensuring that all children and their families, regardless of family formation, receive the same protections and security of legal parentage. As the Attorney General noted in his written testimony, the bill ensures that our laws reflect our state's longstanding commitment to equality and inclusion, and marks a critical step to realizing the promise of full equality for LGBTQ and non-marital families in Connecticut. It is a promise mandated by our Constitution and by our state's own values. Thank you.
Thank you, Representative Cohen.
Thank you, Mr. Chair. Sarah, it's so great to see you. And I just want to comment on the fact that, that Professor Nugent has really made this a teachable moment for you and your classmates. And having your involvement and has just been a tremendous piece of this overall picture. And I know I've been out, and I know Representative Stastrom has been out and had the pleasure to speak directly with Professor Nugent's classes over the years. So again, I just want to thank you for all of your efforts. Please extend that also to your classmates. And as we continue to work on this over the coming weeks and months. Thank you, Mr. Chairman.
Thank you, Representative Curry.
Thank you, Representative Curry, Representative Blumenthal.
Thank you, Mr. Chair. I just wanted to say hi and thank you to Ms. Sampoli. Appreciate your testimony. And I wanted to say a thank you not only to you, but all your fellow clinic students. As a former YLS LSO clinic student myself, I know that as brilliant and hardworking as Professor Nugent is, he doesn't do it alone, and your work has been instrumental to this bill, I know. So thank you again to you and all your fellow students.
Thank you, Representative Blumenthal. Further comment or question from members of the committee? Comment or question? Seeing none, Ms. Sampoli, I want to thank you for joining us today and offering your testimony. I hope you have a great day.
Thank you, you too.
We'll next hear from Jay Sargent.
Hello, good afternoon, members of the Judiciary Committee. I believe you can hear me okay, correct?
We can. Go ahead.
Yeah, okay, thank you. For the record, my name is Jay Sargent. I'm the president of the Connecticut Association of Pawnbrokers, and I own multiple businesses in the greater Waterbury area. I'm speaking to you today in support of House Bill 6564, an act concerning secondhand dealers, precious metal dealers, and pawnbrokers. On behalf of our members and our industry, many of which have multiple businesses in Connecticut, employing hundreds of people throughout the state. As you probably are aware, under current law, licensed secondhand dealers and precious metal dealers who hold such licenses issue a check or a draft when buying goods from a customer. This has been in effect for the last 10 years. The shop can then cash its own check to provide payment in cash if the value of the check is less than $1,000. However, on July 1st, the practice of these dealers cashing their own checks, which benefits our customers immensely, will effectively be removed. This will negatively affect the customer and should not really be allowed to happen. To be clear, we are simply asking a couple of things to be removed from the statute, including the sunset date, as we've come to call it. And so the way we continue doing our business currently will be preserved, along with all the record keeping, record filing. I listened to Mr. Rinaldi's testimony earlier. We all will continue, as we have for the last 10 years, to submit the records, which are then uploaded to NESPIN, which has helped tremendously in recovery of stolen property. Over the last 10 years, our business has evolved immensely. It has changed. We are no longer the type of businesses that deal with a lot of the people that he kind of put on us earlier in the testimony. Many people who use the pawn shops are lower income or unbanked, meaning they don't hold a bank account. This also means they don't have access to services of a bank to cash a check because they do not have enough money to maintain an account. No account means they have to pay fees to get a check cashed somewhere else. So simple transactions like cashing this check are time consuming and costly to the consumers, instead of receiving cash in amounts of lower than $1,000 from the pawn shop. This problem gets even worse on weekends, holidays, after hours, when all these type of places are closed. These individuals can miss work, have their electricity shut off, miss their rent payments, won't be able to get gas for their car, groceries for their family. As a result, people from lower income situations, hardworking families, are at greater risk of being harmed if this legislation, the current statute, is not changed. And this is pretty much our last chance to get this done, as the expiration date is coming upon quickly. Our association back in 2009 initiated and worked diligently with law enforcement and other officials to construct the current regulation that passed in 2011. It was both workable and real world business and useful to law enforcement agencies alike. The current regulations should be able to continue without interruption, along with the relationships that we've built with our local law enforcement. It has shown that all of this has shown that this expiration date is no longer needed for our industry, as it has greatly evolved, as I had said. Over time, the last 10 years, our relationships with all of our local, state, and law enforcement has grown to the point where we file our weekly reports or daily reports, and it's worked very well. They recovered what they recovered, is, as Mr. Rinaldi had stated earlier, $8.0 million.
Mr. Sargent, your 3 minutes of elapsed. I just needed to summarize the rest of your testimony.
I have submitted written testimony as well. I'm free to answer any questions you may have.
Great. Thank you. Senator Champagne.
Thank you, Mr. Sargent. Where did you say you're from?
I'm from Waterbury, my business.
Back probably actually quite a few years back now. I was a policeman in Vernon, and I actually went down to Waterbury and dealt with some of the pawn shops down there. And you guys were beyond helpful. And I was able to solve multiple cases of involving over $35,000 worth of thefts over a 9-month period. And what you're saying is you want to keep what you're doing intact, so that it doesn't interfere with helping law enforcement. Is that what you're saying?
Correct. All the regulations otherwise will be intact. The record keeping, all the holding periods. Actually, this bill also extends the holding period from 5 days to 10 days for jewelry purchases, which will actually help law enforcement even more in recovering property.
Okay. And how does it help you? Obviously, you're here, you want to keep it. How does it help you as a business?
this bill doesn't really help us very much at all. It's going to help the consumer. We still do our business the way we do it. The only thing that will change if we don't get this bill passed this session is that the customer will be left with a check in hand instead of cash to do what they need to do.
Okay. Thank you. And thank you for showing up today to testify.
I very much appreciate that. Thank you.
Thank you. Further questions or comments from the committee? Seeing none, I want to thank you for being with us today, Mr. Sargent, and for your association for bringing this to us.
Thank you. I appreciate the opportunity.
Next up will be Mike Martorelli.
Hi, can you hear me?
We can. I don't know if your video works, but we can't see you.
I'm sorry.
Now you muted yourself.
Okay. You can hear me now?
We can hear you, yeah.
Okay. Is it okay to continue to speak without my video working?
Sure.
Okay. Distinguished members of the Judiciary Committee, I want to thank you for your time today. My name is Michael Martorelli, and I've been the owner of Meriden Pawn for 27 years. I'm here today in favor of House Bill 6564. I believe now more than any other time, we need to make it easier, not harder, for those who are unbanked, allowing them access to funds they desperately need and not creating another hurdle for them. Most major banking institutions for cashing a check, an example, TD Bank charges $10 for a non-depositor, Wells Fargo is $7.50, and Bank of America is $9. Also, extending the hold period from 5 to 10 days on precious metals, if my memory serves me correctly, was already suggested by the Connecticut Association of Pawnbrokers years ago, which I'm also in favor of. I believe this bill is a plus for all involved, and I would be open to answer any questions you may have today. I appreciate your time. Thank you.
Thank you. Questions from the committee? Senator Champagne.
Thank you. Sorry, I'm running a couple meetings here. Just one question, Mike. When you stated something about the check cashing. When you issue a check to somebody, you also get identification from them, correct?
Yes, sir. That's part of our reporting process. So we take a digital scan of the ID.
And then when you issue them the check, they obviously have to sign the check. So they're actually signing there. Do they sign anywhere else?
Yes. So we do, whether it's a pawn transaction or a purchase transaction, they also sign that as well.
Anything else? I mean, for those that are there selling, legally, it's not really, it takes a couple minutes, but it's not really a problem, correct?
Not a problem at all. They're all hopefully selling legally.
And so far, I found that the pawn shops are really good at notifying the police when they see suspicious activity. So far I like what I'm hearing, and I like this bill. Thank you.
Thank you for your time, sir.
Thank you, Senator. Any further questions? If not, thanks for being with us today, sir.
Thank you.
Next up will be Jay King. Mr. King, you're muted. We can see you, but we can't hear you.
How about now?
Yep, all good.
Okay, sorry about that. Anyway, we lost power on this grid here today, and I'm running on a generator, so it might be a little dark. I apologize for that. Anyway, good afternoon, members of the Judiciary Committee. My name is Jason King. I own Yankee Peddler and Pawn in New Britain. I'm very much in favor of support of House Bill 6564. We've been helping people here in New Britain, in the New Britain area, for over 25 years, whether it's money to pay for a utility bill, to buy food for their family, pay rent, any number of other unforeseen expenses that all of us come across. The reason we have been able to help this community is due to the fact that we can provide cash for our customers. For the past 10 years, we issue customers checks when they're pawning or selling items. and we are able to cash those checks as long as they are under $1,000. Let me see, customer check. They are able to pay their bills immediately. No looking for transportation to the bank if they have a bank account. No going to check cashing stores and losing part of the money they just received. No waiting to the next business day if they do a transaction after banking hours or on the weekend or holiday. The current law allows pawnbrokers, secondhand dealers, and precious metal and stone dealers the ability to pay customers via check and then cash those checks at no cost, assuming they're under $1,000. This is an invaluable asset to our customers. I ask you that you let us continue this practice for those who hold the above licenses. Please remove the July 2021 sunset date and help our customers and community continue as they have for the past 10 years. Furthermore, by removing the grandfather clause and allowing all pawnbrokers to operate in the same manner, regardless of when their licenses were issued, will level the field for all in the industry. Thank you for allowing me time to speak today, and I hope you can see what a negative result not correcting this statute immediately will have on the urban communities in Connecticut. Thank you.
Thank you, sir. Questions from the committee? Seeing none, appreciate you being with us.
Thank you.
Next up will be Michael Fisher.
Good afternoon. Can I be heard?
You can. Go ahead, sir.
Thank you guys for having me on. My name is Michael Fisher. I am in support of the House Bill of 6564. I've been employed by Celestine Pawn with their Bloomfield and Vernon location. And give me 1 second here. I found that a majority of our customers come from all different walks of life, do rely on the pawn shop and other sources of alternative financing when they're not banked. They don't have bank accounts. My test stand by not passing this proposed bill and eliminating the expiration date that we have on how we operate under the current statute for the last 10 years would make transactions difficult, inconvenient, and even impossible for our customers who are also your constituents that most of us take for granted. We have an efficient process in which we keep strict record keeping, including cashing our own checks and drafts in our records. Any amount that is settled on at least $1,000 or less is then issued a check here in-house. The customer signs it, and we pay them out in the cash. Under the current regulation, without removing the sunset date, any of our customers that is banked or unbanked will be subjected to not only the inconvenience of having to take unnecessary steps in finalizing a simple transaction by now having to go to the bank, but also the possible likelihood of incurring additional charges by those banking institutions, almost defeating the purpose of the help that they're looking for. Our customers are already being pushed into alternative finance situations to make ends meet. We don't see any need to have them be inconvenient as well. Thank you for your time.
Thank you, sir. Questions or comments from the committee? Seeing none, appreciate you being with us.
Thank you.
Next up will be Chad LaPlante.
Hello, can you hear me?
We can.
All right. Just trying to get the video to work. Okay. Hello, Mr. Chairman and Judiciary members. Hello, my name is Chad LaPlante. I'm Vice President of the Association of Pawnbrokers. I own 3 pawn shops in New London and Hartford counties. I'm here to support Raise Bill 6564, an act concerning secondhand dealers, precious metals and stone dealers. Sorry, I'm nervous. Apologize. As today's works, we issue a check when buying our customers' goods. At the time of issue, we can cash our own checks up to $1,000, which benefits our mostly unbanked customers. By not removing the sunset date on July 1st, 2021, so we cannot cash our own checks will put a huge burden on our already struggling customers, especially in these difficult times. We are looking to continue to do business as we've been doing that helps the community that we serve. So with that said, I'm asking on July 1st, the sunset date to be removed so we can do business in our current way. I am also in support of the extension of the 5-day, going from 5-day hold for jewelry to 10 days to refrain of disposing any metals that we purchased. So that gives the authorities extra time to review transactions. We are a small business looking for support on these changes so we can continue to help families in our community who need it most. Thank you for your time.
Thank you, sir. Questions from or comments from the committee? Seeing none, appreciate you being with us. Next up will be Rafi Podolsky.
You can hear me?
We can. Go ahead, Rafi.
Thanks very much, Senator Winfield, Representative Staffstrom, members of the committee. I'm going to take you to a completely different bill. I'm here to speak about House Bill number 6490, which is the bill that deals with grandparent visitation. Those of you who've been on the committee for a while know I've been here before on a similar bill. We are opposed to the bill, and we would ask the committee not to proceed further with the bill. And this is an old issue. Part of the problem here, setting aside any issues of sympathy for grandparents, is the Supreme Court has twice in major decisions dealt with the issue of under what circumstances does the right of family integrity, which is really a right of the parents, limit the ability of third parties to litigate over visitation rights. In my written testimony, I cite you to the two cases in particular. And that really has established a pretty high standard for third-party visitation. Two things are required. There has to be a specific kind of standing, which is the applicant must have a parent-like relationship with the child, and there has to be a real risk of harm, which is a harm to the child that would come from lack of visitation, not a harm to the grandparent, but to the child. And those have to be laid out jurisdictionally up front by affidavit so that there's a threshold before the litigation can even begin. So these standards came out of Supreme Court litigation where the Supreme Court interpreted what was constitutional and what wasn't. And about a decade ago, back in 2012, the legislature created a grandparent visitation task force to kind of figure out how far could the statute go towards sort of a liberalization without crossing over into unconstitutionality. And that is actually what is in the statute today, is the version that was adopted after these cases came down, and it was the legislature's effort to balance it out. This bill kind of throws that whole thing away. It pays no attention to what the Supreme Court said was required, creates a different standard, which is compelling circumstances without subcategories, does not follow either of the required aspects that were in the Supreme Court decision. And it just seems to me that it's sort of directly unconstitutional in light of what the law is in Connecticut. I also talk some in my written testimony about kind of the policy reasons why you might want to put yourself in the shoes not only of the grandparent, but also of the parent, and under what circumstances people cannot reach an agreement outside of the court structure for visitation. And typically there's some kind of history of hostility between the parent and the grandparent that leads the parent to be suspicious of what the consequences of visitation will be. It can be a two-way fault. Either side can be, if you were sort of trying to take a step back and say who's really at fault here. It's not that it's always the parent who's at fault and the grandparent who's not. It can be sometimes either ways. And because of the fundamental constitutional right of family integrity, that is what has led the Supreme Court to go the direction it has gone. So under all the circumstances, our request to the committee would simply be not to go further with the bill this year. I'm happy to answer any questions I can. And as I said, my written testimony goes into more detail. Thank you.
Thank you, Attorney Podolsky. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, and good afternoon.
Good afternoon.
Podolsky. Sir, I would assume that you've reviewed the bill that's before us here today.
Yes. Yes, I have.
And is there any portion of the modifications to the bill that you would be in favor of?
Well, in earlier versions of the bill, if you could, but you're now going back quite a few years, there wasn't any effort to limit the bill to families that were divided, where one of the parents, say, had died or the parents were not living together. That, in a sense, is a plus in the bill in terms of trying to narrow its coverage. I don't think it solves the constitutional problem because the court cases themselves involved essentially divided families. But so that's something that's that's a recognition, that's a positive recognition, if that's what you mean.
Yeah, no, and I thank you for that. And I believe in those cases, Roth v. Weston, the Castagno case, all of the parents were alive, correct?
Were a lot. I guess I'd have to look back. I'm not 100% sure. Castagno essentially was overruled by Roth versus Weston. So that was an older case that did set a looser standard. Roth versus Weston is really the case that set this particular standard, and DiGiovanni versus St. George kind of followed and reaffirmed Roth versus Weston.
And essentially, I'm sorry, were you done?
No, I'm sorry.
Essentially the Supreme Court found that the children are the children of those parents and that they have the right to determine what they believe to be in the best interests of the children, and whether or not they chose to have their children in the company of their parents, the grandparents here, was their choice as parents. That's basically the fundamental law here, correct?
Yeah, I think that's a fair statement. Again, subject to certain exceptions, but yes.
But this law before us addresses when the parents are deceased, because presently, if the parents were deceased, what would be the process under our current law for a grandparent to get access to their children?
Under the current law, what if there's no agreement? I mean, presumably there is I don't know if you're thinking about a situation where both parents are deceased. The situation this bill is really addressing, among others, where it could say both, but it's really either of the parents is deceased, the parents are divorced, or the parents are living separate and apart. Those are the three conditions that this bill describes. I mean, so are you asking a question about a situation where both parents are deceased or where one is deceased?
That's part of what the legislation says. It says one of the prongs is either or both parents of the minor child are deceased. So that's certainly one of the changes to the law that this this bill proposes. So what is, absent this addition to the law, what is the procedure by which a grandparent would have to follow where both parents are deceased?
I think, I guess I'm going to qualify this by saying I'm not 100% sure, but where both parents are deceased, I think you would end up in probate court with a guardianship proceeding of some sort, or you would end up in an adoption proceeding. As if this is really, the existing statute assumes that there is some parent or one or more parents with custodial rights in regard to the children. So if you had a situation where there were literally there was no person with custodial rights, because let's say both parents were in a car accident and died, then I think you would end up in probate court, which would be a whole different, that would be a whole different issue and a whole different standard. So this is more of a situation where the parents who are alive, either both, it could be both, well, presumably under this statute, the parents would not be living together. So that the parent who has primary custodial care of the child is not willing to allow the grandparents to visit. That would sort of be the circumstance. If it was one of two, let's say you had joint custody and it was one of two parents that was objecting, well, the grandparent's going to be visiting when the child is with the other parent. So you wouldn't end up in court over that, because the grandparents, in fact, would have access to the child through the grandchild through their own child. Here you have, what this anticipates is a situation where neither of the parents it will allow the grandparent to visit, or there's only one parent who has custodial control. And that's what this situation deals with. And the question becomes, when does the law want to say that the grandparent can go into court and insist upon a court decision, not on custody, but on visitation? And that is where the Supreme Court has said this, that where you're talking about visitation, unless there's something specific and very serious, the parents cannot be made to litigate the issue.
Well, thank you for that, but I bring your attention to beginning on line 10 through line 13 of the bill that's before us. It clearly says the Superior Court. So this is not a probate court petition. This is perhaps a situation where the probate court may have appointed a guardian who's not a grandparent. So we can assume that at this point, because probate court's not mentioned here. And moving on to line 12, we have to have a verified petition, which means it has to be signed under oath by someone, by, in this case, a grandparent. And they have to attest that either or both parents of the minor child are deceased. So this is certainly the situation, potentially, under this language, that both parents are deceased. The probate court has appointed a guardian, and one of these grandparents seeks to have access. I'm not aware presently of any way that they would be able to do that without this language, you know, except for that very high bar. I think we all recognize it's a very high bar. Am I correct in that?
I don't think so. I think you were not, but I don't. I would need to go. I'd be happy to look into this more. I really feel that you've asked me a question I don't know the answer to for sure. I thought that, as I've said, I don't want to be redundant here. I've thought that you would be able to go into whatever court had chosen the guardian, and you could make a request, and this statute would not actually be dealing with that. This is a Superior Court visitation statute. So where you've got a guardian appointed by a different court, I would think you would go to that court, and I don't think this statute is applicable, but I could be wrong. And I'm more than happy to look into that and try and verify whether that's correct or not. My sense is that because this statute would not ordinarily be dealing with both deceased parents, it's simply not something that the bill has been written with regard to or for that purpose. I don't know who sponsored the bill. Maybe it was written with that in mind. But if that was the case, it would probably then be limited only to cases in which both parents had died. The whole framing of the bill seems to be primarily about situations where the parents are either divorced or separated, or where one of the parents have died. So you're right in saying the bill certainly has that language about both parents, but I don't think ordinarily you would be in Superior Court in that case. I will try and get you more information, though. I'm happy to do that.
Yeah, I'd appreciate that. So then we take it to the one step back, and only one of the parents is deceased. You would still have that high bar. Well, let's take it this way. Both parents are alive, father and mother. Father says, yes, access with my parents. Mother says no. In that case, more than likely, you know, assuming the parties are separated, dad's going to take the kids to his parents' house on the weekend or whatever. He's going to do what he wants. But in the scenario that now dad has passed, without this language, dad's parents would have to petition, prove that they have a parent-like relationship with those children, and that absent that access, that it was akin to neglect or abuse on the DCF standard. Correct?
Yeah, that's right. That's my understanding of the court decision. As I understand the court cases, what has to be proved, for example, in relation to parent, in regard to parent-like relationship, is really that they have had a parent-like relationship because the cases seem to, now it's not that you do at the moment, because presumably you don't at the moment. That's exactly what the complaint is about. But that you have, at least within some recent time frame, had one. And I think the trial court cases have generally interpreted it that way, so that they're looking back to see, well, what was your relationship with the children?
Yeah, it has to be.
So the mere fact that the parents, either one parent's not alive or that they're separated, doesn't mean that you're only talking about present. But yes, within that framework, the answer to your question, I believe, is yes.
Yeah, because I've done these cases on behalf of grandparents. I've done them on behalf of parents objecting to the grandparents. So I'm very aware of that situation. But my concern is, dad is now passed. Grandparents have had regular access, not a parent-like relationship, but regular access. And now dad is gone. And all of a sudden the grandparents are put into a position of meeting a very high bar to continue that somewhat regular access with their grandchildren. How am I to wrap my arms around that absent this?
I think it's a difficult situation. But I don't think it can be fixed by statute. I mean, I think that is, if you're obviously familiar with the court cases. If you go and look at the Supreme Court cases, that is what the Supreme Court is saying that in the absence of one of the parents essentially being a consenter, that this is the bar that applies to third parties, and it explicitly applies to grandparents. The constitutional decisions do not create an exception for grandparents. And so I think you're right. I agree it's a high standard. But I do think that's what the decisions say, and they say it as a matter of constitutional law. I mean, some of it is a recognition of the fact, in the case you're describing, one of the parents dies. The surviving parent, in reality, goes on to build another life, and perhaps create a different family. That the right, constitutional right, rests with that initial nuclear family, and with that nuclear family, in your example, impossible to recreate because one of the parents has died. That the surviving parent may move on, may move out of state, may remarry, there are all sorts of things that can happen. And I think the court was saying that the grandparents cannot, there are limits as to the ways in which the grandparents of the parent who died can go through the court system to compel a parent who has moved on to another life that they must maintain an ongoing relationship with the grandparents. I mean, you may feel as a matter of policy that's not good policy. I think probably that the legitimate questions as to whether it's too rigid an interpretation or not, but there's a reason for it. I mean, it's not like it's irrational. It's a reason for it, and it's a weighing in favor of the direct parent relationship. And I think behind it is a recognition that sometimes there are real generational issues, or between the in-laws. I mean, the in-laws may not there may be hostility on both sides between the parent who's the custodial parent, the surviving parent, and the in-laws of the ex-spouse or the ex-boyfriend. And this is the way, and the Supreme Court did its weighing and came to this conclusion. So I think that, I guess I just don't, to me, it seems it's not a bill that should move forward, because all these it has constitutional obstacles, and it also has, I think, very legitimate policy questions about where you draw the lines in those circumstances.
No, and I thank you for the discussion. The constitutional obstacles, I still think that in my scenario, dad, although he's passed, and his family, maybe they have some level of constitutional right that isn't recognized by the system. So I thank you for the discussion, and hopefully we'll talk in the future about
Sure.
this.
I mean, I'd be happy to talk with you about it more.
Yeah, thank you, Mr. Chairman.
Yeah, thank you.
Thank you both. Questions from the committee? Further questions? If not, thanks for being with us, Attorney Podolsky.
Thank you very much.
Next up will be Laura Beth Corey.
Hello, can you hear me?
We can. Go ahead.
Okay, thank you. For the record, my name is Laura Beth Corey. I am a certified public accountant licensed by the state of Connecticut and also a managing partner of Silas Dean Pond's Plainville location. The purpose of my testimony today is to strongly support HB 6564 and to repeal the sunset date and grandfather clause. As everyone can agree, providing equal opportunity to receive goods and services without prejudice or exclusion of the underserved and minority communities is essential. This past year has proved most challenging and daunting for many citizens and communities throughout our state. Throughout the pandemic, our industry has remained open and fully committed to serve our communities. We have consistently provided valuable services under the current guidelines and have upheld a high standard of moral ethics and supported local police efforts. Our customers regularly thank us for providing them with our services. We often hear that we have made a significant difference in their ability to pay their rent, feed their families, put gas in their tank, and meet other simply basic needs. Licensed secondhand and precious metal dealers offer a unique and necessary service to a wide range of customers, from the unemployed to professionals, and from the homeless to the wealthy. And some customers can simply come in, sell the goods, cash their check or deposit it, and wait for it to clear. And these individuals will not suffer from the proposed sunset. However, many individuals do not enjoy the access of traditional banking, or they may have needs which arise outside of regular banking hours. It is in these circumstances when we prove to be an invaluable lifeline. Our goal is to continue to offer this much needed service into the future in a safe and regulated environment, just as we have been doing. Cashing checks in-house is solely for the benefit and safety of the underserved. The sunset is biased and prejudicial to the unbanked citizens, and it will unnecessarily diminish the value of their assets by forcing them to seek a check cashing establishment and incur unnecessary expenses. An item sold for just $20 to buy essentials like food, diapers, or formula may only net $5 after transportation and check cashing fees if they are sent elsewhere. It is biased to force the unbanked to choose. If they have to choose between paying unnecessary fees or conducting business through other private seller marketplaces where they may become victims of a scam or even have their safety compromised. So you should also consider that alternative private seller transactions will adversely impact the state's ability to collect sales tax on those resale transactions, which are no longer of record. So in order to continue providing responsible service to all citizens without prejudice, I urge you to repeal the sunset date and allow secondhand and precious metal dealers to continue to cash checks for transactions of less than $1,000. Thank you very much for your time and consideration, and I'm always available to answer any questions you have.
Thank you. Questions from the committee? Seeing none, appreciate you being with us today.
Thank you very much.
Next up, we'll hear from Callie Higgins.
Good afternoon, chairs and members of the Judiciary Committee. My name is Callie Higgins, and I am a student at Yale Law School and a resident of New Haven, Connecticut. Along with my colleague, Sarah Sampoli, I speak on behalf of over 40 fellow law students who have worked on House Bill number 6321, the Connecticut Parentage Act, for the past 2.5 years. Under current Connecticut law, children of same-sex couples lack legal protections available to children of different sex couples. Enacting the Connecticut Parentage Act will help realize the promise of full equality for LGBT people in our state. As a queer woman who met her partner here in Connecticut, this Act's provisions hit especially close to home. So much of how I'm able to imagine my own future hinges on the choices that lawmakers will make. This could not be truer than when I think of becoming a parent. Current law in our state treats many queer parents as legal strangers to the children they are raising. The CPA will recognize the full diversity of Connecticut families and ensures that queer parents are treated equally under the law. The Connecticut Parentage Act updates Connecticut's laws regulating assisted reproduction and surrogacy, enabling queer people like me to become parents without worrying that the state will deem us legal strangers to the children we are raising. For LGBT families, becoming a parent is often already an incredibly time-consuming and expensive process. The Connecticut Parentage Act reduces this stress and legal uncertainty. The Act also sends a clear message that LGBT parents' relationships with their children are just as valuable and deserving of respect as those of straight parents. A year ago, my sister and her same-sex partner had a beautiful baby girl. Since they live in a neighboring New England state that has already enacted these parentage laws, they had the certainty of being her legal parents from the moment she was born. In the eyes of my little 1-year-old niece, both of these women are her parents. And thankfully, their state gives them the dignity and responsibility of being her legal parents too. It is my hope that you choose to extend the same right to me by passing the Connecticut Parentage Act. Thank you.
Thank you. Questions to the committee? If not, appreciate you being with us and your work on this bill. Sorry, the joys of working from home. My own children knocking on the door. Next up will be Olivia Rinks.
There, thank you. Hi there, and thank you, members of the Judiciary Committee. My name is Olivia Rinkus. I'm from North Stonington, Connecticut. I'm testifying today in opposition to SB 363, an act concerning the duties of the Office of the Attorney General. The Attorney General represents the state, therefore, any investigations by the Attorney General into the violation of civil liberties is a conflict of interest. The Office of Connecticut's Attorney General has shown time and again that their interests do not align with those of the people. Attorney General William Tong represented employees of York Prison in the lawsuit against the women's prison by Tiana LaBoy, alleging denial of medical care. He also represented the state in a lawsuit brought on by the state of New York, attempting to restrict the dumping of dredging materials into Long Island Sound. Accountability for the violations of civil rights is definitely needed, but it is needed at all levels, including that of the Attorney General and other states' attorneys. Excuse me. For that reason, I oppose SB 363. Thank you.
Thank you. Questions from the committee? Seeing none, appreciate you being with us today. Madam Administrator, have we missed anyone? Madam Clerk?
That's everyone on our list.
Okay. All right, then with that, I am going to declare today's public hearing closed. I thank the members for being with us and certainly for getting off to an early start this morning on our committee meeting. We will be back together on Wednesday for a public hearing on a bunch of fairly meaty criminal justice bills. So we look forward to seeing everybody then.